But yes, in original site. Though absolutely improper, I tell you, Lordship, item number 4, I am the contemners.
Original site.
Original site. Item number 4, I am the State Warehousing Corporation. I am the contemner. But a fixed matter is going at code number 12. Item number 2, it may carry. But if your Lordship give me an account, in case I am not there, my Lordship kindly. Otherwise, I shall try. If the code doesn't say,
Let us see. Yes. Call the list. Call the list next.
One application.
Inclusion, just hand over. Inclusion in the list, hand over this.
My building will be demolished. The order passed by the trial court on 20th September. Immediately on 4th October, I filed the appeal. Now, when the stay application has been filed, demolition, they have came.
20th September, single judge's order. Stay application filed on
Yesterday.
That is the urgency, Mr.
I filed the appeal immediately on 4th.
Doesn't matter. Stay application has been filed 10 days after that. It will be listed.
In Puja, 6 stories building.
Doesn't matter.
Your Lordship, kindly.
Just so no
story building. For preparation of the sketch map and maybe demolition during the Puja.
We will order demolition. If you don't have a sanction plan, we will order demolition tomorrow. Come, it will be listed. You serve?
Everybody,
serve the appeal papers.
Under the
kagoj jodi thake kalki list diye diyo.
Under the compelling circumstances, millet, I'm preferring this millet appeal without certified copy millet to be moved on the Monday. Millet, what happened here, millet?
I don't want to know what happened now, sir. When was the order passed?
Yesterday.
Leave granted.
On the Monday, millet.
Lordship, may I be permitted to mention one matter, Lordship? We have seek leave to file this appeal, Lordship, on 9th, Lordship. And probably it will be listed by 11th, Lordship. Today, Lordship is not in the list, Lordship. And urgency is that, Lordship, by virtue of the order which is under challenge.
An appeal, you want that to be listed?
Lordship, that has been, we gave the date for 11th to be listed, Lordship.
Yes.
And we filed an stay application for the impugned order, Lordship, which is under challenge, Lordship. And the advocate for the municipality is also
we have not followed till now.
Now, Lordship, urgency is that, Lordship, by virtue of the order which is under challenge, they have issued one notice, Lordship. The hearing date fixed today itself, Lordship. If it
what do you want?
Lordship, we stay of the impugned order, Lordship. We are asking for the stay
not
of the
possible. It is not in the list, not possible.
Lordship, if the unlisted by 2 p.m, Lordship, I am led by Mr. C.G. Bhattacharya in this matter, Lordship.
Doesn't matter who's leading you, sir.
Yes, Your Lordship.
It doesn't matter in this court, at least.
Yes, Your Lordship. Now, the urgency is that, Lordship, otherwise they will conduct
the meeting. Attend the meeting, yes.
Attend the meeting. Grateful, Your Lordship. Lordship, for the inclusion, Lordship, by tomorrow.
দেখো যদি কাগজ ফাইল পাও তাহলে দিয়ে দিও।
Lordship, let the matter be listed by tomorrow, Lordship.
Grateful, Your Lordship. Your Lordship was pleased to pass an order, my lord, on 22nd August, my lord. May I hand over the copy of the order?
What do you want, Mr.?
My lord, after, my lord, this appeal was disposed of, my lordship, pleased to dispose of this appeal, my lord. My lord, they have again started, my lord, making an unauthorized construction, my lord.
So in the dispose.
My lord, the respondent number 9, my lord. My lord, at the time of filing of the writ, my lord, it was G+3. At the time of filing of the appeal, my lord, it was G+6, my lord. Now, my lord.
It's a new cause of action, I think. It's a new cause of action.
Lordship, your lordship is pleased to refer the matter to the municipal tribunal.
We have disposed of the matter. We have become functus officio.
They have again started making an
whatever
construction, your lordship.
Question, new cause of action, I think. So, for my understanding, this is a new cause of action. I don't know whether my
they were supposed to start make us parties within 2 weeks, my lord. There's been a flagrant violation of your lordship's order.
What do you want us to do? If it is a violation, file contempt.
Contempt file.
In a disposed of appeal, what can we do?
My lord, the urgency is, my lord, if the building collapses by any chance, my lord, there will be havoc absolutely in the locality, my lord.
You have to file a contempt application.
File something. We have nothing before us. Oral submission from the bar, being prompted by your learned friend. How can we pass any order on that basis? We must have something before us.
My lord, they were supposed to serve us at least within 2 weeks, my lord. That is also not being done, my lord.
Madam, this is a disposed of matter. It's a new cause of action or whether it is a,
Your lordship would kindly see the order, my lord, once, my lord.
That won't help. We can't pass any order without you filing something. Yes.
One appeal, my lord has made it returnable tomorrow, but my client has filed a cross objection. I'm only praying for enlisting it.
Give the number.
My lord, may
These matters were disposed of day before yesterday in the Bhatkara municipality matters. Lordship, in those matters, Lordship, contempt application had been filed before the learned single judge. Now, Lordships have modified the order and have extended the time. So my contempt becomes infractious. If Lordship adds one line that contempt may be allowed to be proceeded after the stipulated.
Why infructuous? Why infructuous? Adjourn it beyond that period. Have the contempt application adjourned. We have given a time period.
Yes.
Have the period adjourned.
Because my lord has observed that the order is modified.
Sir, we have to extend the time for payment.
Yes. I am not on that. I
Yes.
am not on that. I will be one if there is only one line that the contempt can be proceeded after the expiry.
Nothing.
Hence, Lordship, the contempt they will say.
Nothing.
my lord, may I permit to mention this matter, my lord. On 5th 10th 2023, this matter was disposed of, my lord. We appeared on behalf of the state respondents, my lord. But typographical mistake, our name has not been incorporated, my lord. Kindly incorporate our name.
To be mentioned. তুমি দেখো তো দিয়েছিল কিনা, তুমি তো রেখে দাও নাকি অ্যাপিয়ারেন্স গুলো, দেখে নিও, চেক করে নিও।
To be mentioned. Deeply applied.
Your lordship, in this matter, on the last occasion, my learned senior had appraised your lordship that respondent number 2 had passed away on 8th August
We have
2023.
been informed on 3rd of October, my lord, that respondent 2 has passed away, and we have given the name. We have made the petition ready, and it has been sent for the affirmation and all other things.
This GA5, what is this GA5?
But it is not the earlier. That
Not
is
your application. When do you want it? Tell me.
Let it appear after immediate after the vacation. I hope, my lord, in the name by next week, my lord, it will be filed. Before vacation, it will be filed. And let it appear, my lord.
Mr. Ghosh, learned advocate for the appellant corporation, says that a substitution application has been made ready and will be filed soon for bringing on record the legal heirs of the respondent number 2 who has passed away. Paragraph, let the appeal and any application that may be filed on behalf of the appellant be listed again on November 17.
November 17.
2 appeals, same order.
Same order.
ও একসঙ্গেই তো হচ্ছে, দেখে নাও, একসঙ্গেই হচ্ছে।
Grateful, your lordship.
Your lordship's extreme indulgence and importance. Kindly pardon my importance.
Mr. Ghosh, some kind of discipline, if not maintained,
Before the vacation, my lord,
then
the
why?
papers at least 1 minute late. That's why. Otherwise, I wouldn't have disturbed your lordship's. My lord.
We rise at 12 o'clock, at least wait till then.
My petition.
Let Mr. Ali continue to argue, my lord, because I do not.
You will continue to argue. How long?
Let him continue for, he said, at least he gave me a respite of
15, 20 minutes, I shall
20
argue.
minutes, my lord. Let him do that, my lord. I will take your lordship's leave, my
Mr.
lord, because
Bhattacharjee, we always accommodate. Why are you worrying? You need not tell us. Somebody should be there. You have a junior in the matter.
only indulgence I'm seeking from your lordship is, my lord, there's an item number 2 fixed with the Chief Justice, my lord.
Please don't tell us these things. These are very embarrassing. Please don't tell us these
So
things.
let Mr. Ali,
You choose wherever you want to go. Please
I
don't
want
tell
to
us
go to
I have
both
this
places,
matter
my lord.
there, that matter there, that.
I want to be in both places before puja, my lord.
It's your choice, Mr. Kushal. Yes. Continue.
मैं আসছি।
তোমাদের জুনিয়র না?
Yes.
Lordship. Lordship, on the last occasion, I have made my submissions with respect to I was dealing their defense. The first defense was limitation, to which I gave my threefold reply. First is knowledge would be relevant. Second is that under Article 215, Lordship, there is no limitation period prescribed. And Lordship, I had checked up that with respect to the virus. Lordship, I have Mr. Pal's books I've consulted. There is nothing, there is various divergent view with respect to, but there is no discussion with respect to, it is only one line said that one judgment of the Honorable High Court has held this
To be ultra virus.
to be ultra virus with this observation. And the others, Lordship, the virus has been considered, but Lordship, it's not discussed in that book, the constitutional validity. But it has been held, it has been written in various paragraphs that Article 215, Section 20 cannot limit the power of the High Court under Article 215. That has been the Kerala High Court full bench also, that I have seen it is discussed.
You haven't cited those cases.
No, I have not cited, because, my lord, with respect to virus, Lordship, I do not want to put my case that high. I only want to say, Lordship, Section 20, the High Court derives power, Article 215, as well as from Contempt of Courts Act. Lordship,
Why was it necessary to enact Contempt of Courts Act?
Lordship, for two reasons. One, Lordship, Article 215 says that for contempt of its own order. But for subordinate court also, contempt of court is there. For criminal contempt,
Then the Contempt of Courts Act need not have contained provisions.
Section 20.
Anyway,
But
these are
but
academic.
it is also, Lordship, criminal contempt is also one thing which has been dealt with in Contempt of Courts Act. Lordship, that is the second point with respect to limitation. The third point which I wanted to make, that it is a continuous act, which is, Lordship, the order which has been violated is an order of status quo. So non-restoration of status quo, Lordship, is also one of a continuous act. So their act in blatant violation, in blatant contempt of this honorable court. So there is no question of limitation with respect to a continuous act of violation.
Yes.
Lordship. Now, my lord, with respect to the argument that dematerialization, Lordship, if I have understood the argument properly, I think Mr. Bose tried to say that we had returned the shares because the signature was mismatching. We had returned the shares and it was dematerialized. We had no control on it. Once they applied, we had transferred. If I have understood it correctly. But my lord, when I submit, Lordship, there would be no doubt that with the deepest of respect, it is perhaps, Lordship, is not correct. Lordship, firstly, Lordship, I would like to explain why the order of status quo and why on Tata. Because, my lord, I am the alleged seller. Mangturam is the alleged buyer. So what would Tata do? Why was the injunction on Tata to with respect to these shares? Lordship, in 1992, Lordship knows it, but still for my satisfaction. In 1992, what used to happen, if I wanted to buy, say, shares, I would, Lordship, approach the stock exchange, the broker, and Lordship, I shall take 100 shares. In return, Lordship, I would get the share script and the transfer deed. If it is an, Lordship knows this, intraday, Lordship, I need not even get the share scripts. Whatever I would say, would like to buy, say 100 shares, they would write it. If I want to sell, they would also write that. If there is a difference, a profit, I would get the profit after settlement. If there is a loss, Lordship, I have to pay the loss. If it is in intraday, if I do not want to trade, I want to purchase, then my lord, the share scripts along with the transfer deeds are given. Because if I'm buying, somebody is selling. So the transfer deeds are there. Now I have to lodge these transfer deeds because although I have purchased, in the books of Tata, I'm still not the owner. So, my lord, although I have purchased, I have to lodge these share scripts along with the signed transfer deeds to Tata. Tata will verify the signature with the specimen signature that they have with the transfer deed. And thereafter, my lord, my name would be registered in the books of Tata as a shareholder.
You could be a very good teacher.
My wife says that. Unlike,
Then that must be right.
and she's a professor.
Whatever wife says must be right.
Must be right. So, my lord, so with respect to that, so after I lodge the share scripts and the transfer deeds, and after telling the signatures, Lordship, these shares would be given to me. Lordship, when we came to know that the defendant number one is acting, Lordship, not in his usual course, not bona fide, Lordship, at that point of time, we approached this honorable court. The honorable court was completely aware at that point of time. Defendant number one was a very popular person in this court, and I'm not the only victim. Was completely aware of the situation, and the honorable court said that Tata Tea should not register any transfer with respect to the shares which belong to me. So, my lord, the entire transfer, the so-called alleged transfer, Lordship, is stopped. The registration from the Tata Tea's side. So, although they do have the original share certificates, the so-called transfer deeds, but they cannot be treated to be owner because Tata Tea is injuncted for not treating them as owner, not lodging their shares. So, my lord, that is the background of the order of status quo, the injunction which has been granted. My lord, with respect to dematerialization, with respect to first lordship, I do not think there should be any doubt with respect to this. With respect to dematerialization, lordship, when dematerialization took place, when SEBI has asked that the shares would be dematerialized, they would be made fungible. At that point of time, lordship, the owner of shares has to approach with the share scripts. The owner has to do it. And owner would mean the owner which is recorded in the books of Tata Tea. So the owner with the the share scripts has to approach Tata Tea and they have to fill up a form for dematerializing the shares. So it is not so that the dematerializing is an automatic thing. It has to be lodged and lodged by the owner. Mangturam could not have lost those shares for dematerialization because his name is not appearing. In fact, he has been Tata Tea has been injuncted from recording his name. So the dematerialization which has happened is only after Tata Tea has recorded Mangturam's name, and thereafter the dematerialization took place. Similar, only an owner, the lordship. For that reason, I am carrying SEBI's literature of SEBI, lordship, on dematerialization. Lordship, may I please those? Yeah,
Rakho.
This is
Rakho. Yes.
Lordship, this is with this is from the website of SEBI. Lordship, these are on dematerialization, the frequently asked questions. Lordship, I'm referring to 19 page, internal page 4, question number 19. Because these are, Lordship, there should not be any doubt with respect to these things. Question number 19, may I please, my lord?
Hey, 19 is something else.
This, Lordship, but what I want to say is that can an investor open a single account for securities owned in different ownership patterns, such as securities owned individually and securities owned jointly with others?
Very
What
good.
I'm on is no, demat account must be opened in the same ownership pattern. So, my lord, the ownership is what is vital, same ownership pattern in which the securities are held. So, my lord, in this case, the securities were held by Manmal Bhutoria. So, that security could not have been dematerialized at the behest of Mangturam without, Lordship, them first recording the name of Mangturam. And thereafter, Lordship will see question 28. How can, what is dematerialization? Question 27, what is dematerialization? Dematerialization is the process by which physical certificates of an investor are converted to an equivalent number of securities in electronic form and credited into the BO's account with his DP. BO is beneficial owner. How can one convert physical holding into electronic holding? That is, how can one dematerialize securities? In order to dematerialize physical securities, one has to fill in a DRF, which is available with the TP, and submit the same along with physical certificates that are to be dematerialized. Separate DRF has to be filled for each ISIN. A complete process of dematerialization is outlined below. Surrender of certificates for dematerialization to your DP. DP intimates to the depository regarding the request through the system. DP submits the certificates to the registrar for the issuer company. Registrar confirms the dematerialization request from the depository. And after dematerialization, the certificates registrar updates accounts and informs depository regarding completion of dematerialization. So what I'm on is the surrender of certificate is the primary condition for dematerialization. So, my lord, once the submission, if I have understood correctly, the submission that we have returned and it has been dematerialized, we had no control over it. We do not know how it got transferred. Lordship, that perhaps is misconceived because there has to be a definite surrender of certificates. Without that, dematerialization cannot happen. That's something post the act of contempt. So dematerialization cannot stop. In fact, my lord, if the alternative argument, which they have tried to make, that now it is dematerialized and I cannot, it cannot be made into a physical share anymore. That is also incorrect in view of question 32. Can electronic holdings be converted back into physical certificates? Yes. The process is called rematerialization. So, it's not an irreversible situation. It is definitely reversible. But what, if I have understood correctly, once it has been dematerialized and Mangturam has dealt with it, perhaps they wanted to say that it cannot be brought back. The same shares cannot be brought back. I do not want the same shares. I want the same number of shares. Same share, but not only one. So, dematerialization cannot be a hindrance for the contemners from restoring the status quo. So, one of the Lordship will see the acts of contempt. The acts of contempt if there's anything that's bothering you, Lordship, I can try to assist.
Hey, you.
Huge.
It's Mr. Ali.
Lordship. Kindly seize the acts of contempt. The acts of contempt include by willfully and deliberately transferring 1,000 shares along with all accruals of the respondent number 6, that is the content number one, having distinctive numbers such and such corresponding to folio number in favor of Mangturam Kejriwal and subsequently dematerialize it through his depository participant by willfully and deliberately not taking steps to rescind, recall, and withdraw the transfer of the said 1,000 shares corresponding to folio number such and such. Number 3, by willfully and deliberately not taking steps to rectify the act of contempt despite putting them on notice of contempt. By willfully and deliberately attempting to justify the act of contempt by letter dated September 2, 2022 by otherwise acting in contempt. So, my lord, non-rectification, non-restoration of status quo, Lordship, is also, Lordship, today Tata Tea cannot say whatever has happened and that is that. Tata, once the contemners are put on notice that there was an order of status quo, irrespective of whether they were there in 2006 or not, now that they have knowledge about the act of contempt and about that violation of status quo, that status quo is still not there. Lordship, the status quo ought to have been restored. Lordship, I have in cases, Lordship, where the status quo is irreversible. Say, for example, Lordship, is reversible. Say, for example, Lordship, there is a status quo with respect to nature and character of a property and somebody builds on it, it can be demolished and status quo can be restored. In this case, my lord, the contemners ought to have purged themselves from the act of contempt that they have committed by putting in the shares which are the subject matter of the present suit. 1,000 shares plus the accruals, which comes to around 16,000 or 17,000 shares. The next, my lord, with respect to that is with respect to dematerialization. So dematerialization cannot be a hindrance. That is my submission. The last submission was with respect to the knowledge of the directors. Lordship, as I said, the act of contempt is also non-restoration of status quo. Lordship, in 2006, whoever was there, Lordship, I believe Mr. Ratan Tata was the chairman at that point of time. Lordship, if I do not know what the submission is, that I should have made Ratan Tata a party, but I do not want that the directors ought to be punished. I want that they should be given an opportunity that whether they are going to purge themselves by restoring the status quo. If they are not restoring the status quo, my lord, then that would mean they are acting in blatant violation of the order passed by this honorable court. And a defense like whatever has happened has happened. Now, no reason to cry over spilled milk, Lordship. That is not correct. Lordship, these are shares, lakhs and lakhs of shares are of Tata Tea are there in the market. It can be easily, Lordship, bought by them and restored. The other, my lord, the Lordship kindly takes the convenience volume that I have prepared. Lordship, a submission was made with respect to the transfer deed being revalidated. Mr. Bose said that after post 1 year, it has to be revalidated, and there are rules with respect to that. So, my lord, I agree with Mr. Bose to the extent that there has to be revalidation, but by a competent authority. Lordship, Mounturam could not have revalidated. Either Manmal would revalidate it, which was impossible because he had died, or the competent authority. In this case, neither happened, because had it happened, Lordship will take page 31 of my convenience volume. Kindly seize the last paragraph. Lordship kindly takes page 31 of the CV. Last paragraph.
Yes.
Accordingly, Mr. Kejriwal has forwarded to us a court certified copy of the order dated such and such, along with the share certificate and the transfer deeds, duly revalidated for transfer of 1,000 shares to his name. However, on going through the transfer deed, we find that the signature of the transferor on the deeds totally differs from the specimen signature, which would mean that this time also, had it been a court has certified, this observation would not have been there that there is a mismatch of signatures, because it's a court certified copy. They wouldn't even look at it. The court has revalidated it. But it must be that some sort of forgery has happened. That is why Tata Tea is recording that there is still a mismatch. Although it is revalidated, we cannot act on it. Because we cannot act on it, they refer it to the their board, or the Mr. Vice President and Secretary, for approval. There is no such provision. They ought to have immediately rejected it. Lordship, what I'm trying to say is, Lordship, the willfulness to act on their whatever the Mounturam is given, Lordship, that is there. They did not act as per law, neither as per in terms of the order of injunction. So they violated both. So this is with respect to, Lordship, the issue with the revalidation of transfer deed. Just because it has been revalidated, Lordship, it has not been done by any court of law. It has been done by forgery, and they could not have acted on it. But despite that, they have acted on it. Lordship, I believe Lordship, and again, my lord, I would like to say it is not my intention to prosecute David Crean. My intention is that if the board is acting completely in disregard to the orders passed by this honorable court and asking me to run here and there, despite I have obtained, Lordship, that, Lordship, is very unfortunate, Lordship, and a complete violation, a contempt of this honorable court. And Lordship knows those lines of decision.
Could not the revalidation be by the legal heirs of Manmal? If Manmal had died?
No.
It was the signature of
We
Manmal.
are the legal heirs.
Oh, you are the legal heirs.
Lordship.
Yes.
Lordship, one decision which only one paragraph I would like to cite with respect to again that 215, Article 215. This is a Delhi High Court decision, although it's a single bench. But as I said, my lord, in paragraph 15, I would only place the first two lines of paragraph 15, which is the conclusion. The discussions are there, my lord. I'm not wasting lordship's time.
1 second.
Lordship. Oh, I'm sorry. This is 2004 Criminal Law Journal 4274. This is from Mr. Espal's book. 4274. There are many judgments on this, my lord, that the power under Article 215 Vikramjit Singh. Same.
Yes.
Lordship will take paragraph 15. It is in this analysis that the sundry following conclusions are arrived at. Firstly, that there is no limitation for proceedings under Article 215 of the Constitution of India. Such proceedings are imperative where I'm sorry, madam.
So, academic question. But it's interesting to discuss these things at times. 215 power of the High Court to punish for its own contempt cannot be limited by any statute.
Lordship.
Then the 6 months, maximum of 6 months imprisonment and 2,000 fine should also not apply.
That is why those lines of decisions are there, where
If the High Court thinks it's a very grave contempt, it can be 5 years imprisonment. No, logically, if you take it to the logical conclusion.
It can be so.
Interesting.
But I believe, well, again, I have not researched on this. The endeavor would be to nullify the act of contempt and restore it in a manner, Lordship, that the act of contempt is nullified. That would be if maybe imprisonment will not be necessary.
Mr. Ali, the problem is there's a long line of cases saying that contempt court, the court exercising contempt jurisdiction, is only concerned with either whether there has been a willful violation or not. Any substantive direction cannot be given. That is a problem.
Lordship, that then, my lord, I shall place some cases on this, my lord, because I've seen.
You have to.
I've seen, my lord, that the High Court will not be a mute spectator. It has to, Lordship, there are those decisions. Lordship.
Yes.
But today I'm not armed with those decisions. But, my lord, I have concluded. I shall also file my notes of argument, my lord.
No, but then if you wish to cite those cases, you better do that before they
conclude, my lord.
Because they have to deal with those cases then.
Lordship. I shall.
After vacation?
I would like to finish
more,
it before vacation.
5 more days left. There's some pressure of motions.
Okay, I leave it to your lordship.
Anyway, come back then Monday. Come back on Monday. It will run in the list. Monday?
My lord, he will continue.
Only few decisions. I have otherwise concluded.
He wants to cite a couple of decisions on the point that even the High Court, while exercising contempt jurisdiction, can direct the contemptors to undo the act of contempt.
My lord, yes, undo. My lord.
Let him cite, you deal with it when you.
Yes, my lord.
Isho. Mr. Ali, learned advocate for the petitioner, has almost concluded his argument. Stop. He only wishes to cite a few authorities on the proposition that the High Court while exercising contempt jurisdiction, can direct the alleged contemptors to undo the act of contempt. Stop. Contempt and restore the status quo ante. ANTE, ante. Paragraph lists the matter once again on October 16.
Lordship.
So, my lord, I need not make submission on,
As
The-
you wish, you can immediately make submission. You can make it after the vacation.
If I
no,
get-
no, my lord. Today, I need not deal with all those.
Let him conclude once and for all.
Because, my lord, I have to deal with the.
Yes, yes, you deal.
maintainability as well.
Once he concludes,
I shall try to share my
Because now-
decisions
Two new
with my
decisions
learned
that I
friend.
have to deal with.
now he's running after your clients as well. That
That's fine. I will show whatever.
Well,
is
all are our
cited,
common,
my lord.
common clients.
all
As
are
long as, my lord, they are in our company, they are all common clients. But very soon they may not. Some of them, another new set will come in. For them, another contempt, my lord, will go on. And I wanted to
see-
show you something about the decision.
Tata Iron is the 92.
Yes, yes, you show us on the next day when you argue.
Yes, my lord, paragraph, where? Yes, 10 of the judgment is important.
Speaking of
My lord, just have a look.
Which judgment?
Pratibha Banerjee.
He cited, my lord, Justice
89
Justice
Justice
Pratibha
Pratibha
Banerjee's
Banerjee's judgment.
The ultra vires. As I
Delhi
said, I am
Kobach,
not
Justice
raising my
Pratibha
case
Banerjee.
that-
My
That
lord,
has been since, my lord, 92 Calcutta Division Bench, my lord.
Yes, I have given the judgment,
Oh.
not you. Now, my lord, whatever it is, paragraph 10 is important.
Not today.
Just have a look.
Oof.
I'm
Once
saying, just have a
Result-
look at paragraph 10.
ছাড়ো না সোমবার করবে ওফ
Dr. Taposh Banerjee appear করেছিল।
Oh, acha.
May I take your lordship's leave?
Paragraph 10 is important.
he's up to some mischief, I am sure.
Absolutely.
Maybe my father
Also
appeared
for
or something.
That is why, I mean. But why it is mentioned as Mr., I do not know. In 1989,
কি দিলে গো? There, return 89 Calcutta.
you can see later. You just wanted to.
আগের দিন কতদিন দিয়েছিল?
Yes, you can have my judgment copy.
দাও।
Yeah, just. But ultimate argument was.
This is the,
made
this
by
is,
Mr. A.K. Ganguly, which is later on Justice Ashok Kumar Ganguly. He argued to the contrary. And later on you will find no longer the name appears.
oh, Mr. Taposh Banerjee appeared for the alleged contempt laws. Alleged contempt laws.
And-
And he lost.
No,
No.
no.
Ultimately, there was no
Ultimately, the
contempt.
facts of the case.
Yes.
That's right. But later on, you will find, I mean, the argument is that of a certain Mr. A.K. Ganguly. Yes, later on, Justice Ashok Ganguly. What is even more interesting, which is not in the
But Mr.
judgment.
Somnath Chatterjee also appeared
Yes,
in
he
the.
appeared and argued this point, all this point, that this ultra-virus Article 215. I will show you that it has been set aside. Manner wonderful discussion on all these cases is only one book. And
Espal.
yes,
Hmm.
and he says, which is very strange, it's a new book, new edition, which I purchased. 22. In 22, I purchased. He says that they appeal, apparently an appeal was filed from Justice Pratibha Banerjee's order, and that is pending. It says it's pending. I'm sure it's not pending. So I'm dismissed for default. One of these days, your lordship must say the old matter and gone. I'm sure it's gone. But in subsequent matters, this has been set aside. And more interesting, without referring to that judgment, division bench of Justice Ashok Ganguly took up the matter, not this. And he lost. He was junior to Dr. Taposh Banerjee.
and he commented about this, that what, all this. I just wanted to tell you, Your Lordship, very
A
interesting.
lot of research.
This is typical Mr. Tilak Kumar Bose.
My lord, I didn't have some time. None of them helped. So late night, I was doing some work, doing with some other. I thought about this matter is there tomorrow.
I know him from the presidency college days.
The Lordship knows the best.
And then Cambridge. Yes, very well, Monday.
Your Lordship, item number 4, if it pleases Your Lordship, I am for the petitioner.
You are for the petitioner.
I am for the petitioner, my lord.
Yes.
My learned senior, Mr. Dashgupta, is on his legs.
Mr.
Shoroshi's Dashgupta is on his legs. I was only beseeching Your Lordships if it could be kept at 12 p.m. today. If
This
or
is
on
not of
Monday.
such a
Or
urgent
on
matter.
Monday. There is
Monday
some
after the
urgency.
vacation.
Kindly keeps it on
My
Monday.
lord, keep it after the
What is
vacation.
the urgency, sir?
No urgency. No urgency. Warehousing.
Why can't we have it after the vacation, immediately
My
after
lord
the
keeps
vacation?
it on Monday.
No.
And if my
He
lord
will
is
be in
not
trouble
satisfied,
because his senior will scold him. Come back on Monday.
As you lord.
Accommodation is prayed for on behalf of the petitioner.
No urgency.
Huh? On the ground of personal difficulty of learned senior counsel appearing for the petitioner. Paragraph. List the matter once again on October 16,
I'm grateful.
2023.
If my lord is not satisfied, my lord would keep it.
We'll be getting the smell of holiday, my lord. Therefore, that time, my lord, we cannot concentrate in all those things. Motions will be taken. A lordship knows.
On that day, on your ground, we will adjourn.
Yes, you are grateful.
Yes. First call pass over. This is your cross appeal. 6. Mr. Shoktinath Mukherjee had appeared at some point of time.
Yes, before the honorable single bench, and thereafter, my lord, after the division bench order, my lord, will be approached before the Supreme Court. I got some information with regard to that case, my lord, but till my lord, it has come on in the next one after a long time. If I could not
Mr. Ghosh, are you sure I have not heard this matter sitting singly?
No, not you should not. It is heard by a different bench, my lord.
But why does this matter appear to be familiar to me? Did I consider it as part of some other division bench?
Exactly, I cannot remember because brief could not be.
Anyway, doesn't matter. In the first call, we'll pass it over and then we'll see. Seven. Mr. Banerjee, you appear for the appellant?
No, I'm sorry.
No.
Your Lordship, I'm appearing on behalf of the petitioner in this matter. We have instructions to withdraw this matter, Your Lordship.
This Bengal Chamber of Commerce?
Yes.
That is wonderful instruction, if I may say so.
We are also happy, my lord.
You are for KMC?
Yes, Lord. Yes, sir.
Learned advocate for the appellants says that he is instructed to pray for withdrawal of this appeal. Stop. Paragraph. The appeal stands dismissed.
Grateful.
Accordingly, the appeal stands dismissed as withdrawn.
Grateful.
Interim order, if any, stands vacated.
My lord, in item number 8, my lord, I appear for the appellant. My lord, I need to take instructions, my lord, on this appeal, my lord. So if my lord may kindly keeps it on after vacation, my lord, we will come back with instructions.
Very
My lord, I
clear.
am appearing for the corporation, my lord.
Mr.
No
Alim,
start upon us.
you
Yes,
are
my lord, yes.
you are most welcome to appear virtually, but try to not do it from the car.
No, my lord, I'm sorry, my lord, I was traveling, my
Don't
lord.
do it from the car. Sit well.
I was there in court, my lord. I was there in court,
Yes,
but I had
we saw you. That is why. Anyway, you are appealing for?
For the corporation, my lord. No copy served
Okay.
upon us, my lord.
No copy served.
No copy served.
Serve copy. Lekho. Learned advocate for the appellant says that he needs time to obtain instructions from his clients. Appellant such ekadikachi. Paragraph. list the matter on November 22, 2023. Stop. Paragraph. Learned advocate for Kolkata Municipal Corporation says that no copies of the appeal papers have not been served on the respondents. Stop. Let service be completed in the meantime.
I'm grateful, my lord. I'm grateful. I'm sorry, my lord, to appear virtually.
Item number 9. I appeal for the respondents. They have filed an application. Yeah. না এটা একটা নাম একটা করেছে ওই মুক্তির নাম চেঞ্জ হয়ে আপনারা আমাদের কি বলবো হ্যাঁ বলা কিছু সেটা করে দিয়ে
Yes, Mr.
Yes, one of the heritage matter.
Yes.
You heard this matter. Now they have filed an application. Formal, of course, my lord, that Putti's name has been changed. That application today, my lord, is in the list. And my lord, we have prepared, my lord, the written notes of argument. We are supposed to file it. Since, my lord, this application was not in the list on the earlier occasion, therefore, your lordship, my lord, directed the matter to be listed with that application and the
Lord,
be filed.
Lord, this is appearing, my lord, for two reasons, as he's indicated, learned. Lord, we have filed.
Sit down, have some water if you like. Regain your breath. Let us have some water.
No, Lord, thank you. Lord, I'm so grateful. I'm better.
Something হয়ে গেছে
Milord, this is Milord, the IA has been filed, Milord, only for the purpose so that the Milord, the appellant's name and the registered or address, Milord.
Yes, yes, allowed.
Milord, so page 8, Milord, is the ROC.
Only thing the department will have to carry out the
Milord, I have enclosed, Milord, at page 9, Milord, the required amendments to be made in the cost title because Milord,
page 10 in our copy.
ASL West Enclave Private Limited.
and Milord, the registered address. is
ASL
also-
West Enclave Private Limited.
And address in Mumbai.
No, the address is Milord, Punwani Chambers, 7B, Kiran
7B,
Shankar Roy Road,
right.
Milord, towards the bottom of the certificate.
Issue?
Milord, the
You can have nothing to say. This application has, okay. This application has been taken out by the petitioner for recording the change of its name. Stop. The petitioner is now known as ASL West Enclave, এই page 10 থেকে দেখে নিও, Private Limited, and its registered office is also as indicated in the copy of the cost title annexed to the application showing the requisite amendment.
yes, Milord.
Paragraph, the prayer is of a formal nature. Stop. Mr. Ghosh, learned advocate for Kolkata Municipal Corporation, says he cannot possibly object to this application being allowed. Paragraph, this application is allowed. Stop. The department, allowed. Stop. There'll be an order in terms of prayer A of the application. Stop. Leave is given to the department. The department is directed to carry out the necessary amendment within 2 weeks from date. 2 weeks will take out to the vacation, but all right, within 2 weeks from date.
Milord, if one more week after vacation may begin, Milord, just a week, Milord.
Within a week, 1 week after vacation.
Just one more week, Milord, because since we are having only 1 week.
You will have to re-verify also.
That's fine, Milord. That's the only reason I am seeking for
That
one.
prayer is not there.
Milord, your lordship may grant it, Milord.
Within 1 week after the puja vacation. Stop. After the amendment is carried out, the petitioners would be at liberty to re-verify the petition. Stay petition. Paragraph, the application is disposed of. List this matter once again 1 week after the vacation.
Yes, Milord, because
Date diye dao.
I'm told that Mr. Bose would like to make a submission for 5 more minutes and then the written notes are ready. We can.
Then don't file your notes today.
We have made it, we will not making any submission, Milord. There is a scope to make.
You want to file the notes?
Well, I may file Milord, by written notes of argument.
File 23rd e koro, tarpore lekho written notes of argument filed on behalf of Kolkata Municipal Corporation be kept with the records.
Milord, 23rd November. Great.
2024.
Milord, 2023, Milord.
All right, 2023.
My lord, in item number 10, Mr. Raghunath Chakraborty is engaged.
Mr.
Raghunath Chakraborty, appearing on behalf of the appellant, is engaged in courtroom number 5.
What can we do?
Matter was heard by your lordship, Milord. There are 2 applications there.
Yes,
One
my
is
lord.
review petition is there. I submitted, your lordship recorded that fact. So far as the review is concerned, my lord, that order has been given effect to. Then, my lord, whatever the order was passed by us, my lord, then order was challenged before the single bench passed an order, my lord. That, my lord, not in their favor. Then, my lord, they have prepared an appeal. That also, my lord, with this, my lord, the case today.
My lord,
with the secretary
regarding,
application.
my lord, regarding.
Then nothing remains of the review.
But so far as the review is nothing here. Possibly, my lord, they will ask for, my lord, the section 5 applications, condonation. There is no scope even for passing any interim order in the matter. And otherwise, the paperwork to be filed.
Anyway, Mr. Chakraborty, she says is engaged.
Even, we have a limitation of 164 days, my lord.
In which one?
Review, I am not accustomed with the 10, I am not accustomed, my lord.
Huh?
Item number 10, I am not accustomed with the matter, and my lord.
Which one are you then? We are on 10 only.
11.
No, 10 has been, 10, 11 together. Acha, acha, acha.
Let us come together. He also recorded that since Mr. Chakraborty was not there. I had a talk with him. He says my lord, that I will pay for the limitation,
Yes,
grant
my
of
lord.
limitation.
Condonation of delay in the appeal.
The appeal.
Yes, my lord.
Kullan Bishwas is Nilanjana Bishwas' legal heir or what?
Nilanjana Bishwas had already died. He is no more in the world.
What do you want? Shall we condone the delay?
Yes, my lord.
Let us condone. Then what happens to the review? Nothing remains in the review. Let's dispose of.
He sees now the papers against which the appeal was refusal was filed. Then you will find in terms of the order of the division bench.
We accept what you say, whatever you say, Mr. Ghosh. So shall we dispose of the review application? We'll condone the delay in the appeal.
My lord.
Tell us.
Well, he says, well, he submit. I do not know what he will submit. Then, well, all the both the matters be listed after the vacation, because they are asking for the accommodation.
Why not Monday?
But he says after the vacation.
Monday. If the review can be disposed of.
Yes, it can be disposed of.
Accommodation is paid for on behalf of the review applicant in RVWO 26 of 2016, as also the appellant in APOT 320 of 2023. Paragraph. Mr. Ghosh, learned advocate for Kolkata Municipal Corporation, says that the order under review was implemented by Kolkata Municipal Corporation, and the corporation passed an order pursuant to the order under review. Stop. That order of the corporation was challenged by the legal heirs of the review applicant by way of a fresh writ petition before a learned single judge.
Bishwas filed the review application. Kullan Bishwas and Nilanjana Bishwas is the wife who had died already. Kullan Bishwas filed the writ petition. Writ petition.
Not legal heir tale bolo na. কি বললাম বলো?
Kullan Bishwas and his son. Kullan Bishwas and his son.
Legal heir না বলে বলো by one of the review applicants and his son. The bracket লেখো, the other review applicant having died in the meantime. Bracket close. By way of a fresh writ petition before a learned single judge. Stop. That writ petition also stands disposed of. Stop. The appeal arising from that writ petition is APOT 320 of 2023, which is listed today along with the review application. Paragraph, Mr. Ghosh submits that in view of the aforesaid, nothing remains in the review application. Stop. We appreciate what he says, but since accommodation is paid for, we adjourn these two matters till October 16, 2023.
My lord, I am for the appellant. Lordship, in this matter was against the interlocutory order. Interlocutory order refusing only the interim orders,
The
not
petition
even
has been disposed of now.
Lordship, but there is another order by this appeal court in this matter, 16th October 2020. If your lordship looks into that,
Corporation.
No, my lord. I am for respondent number 7. My
he is the private respondent. It's the only he is the owner of the property.
Mr. Banerjee, if the writ petition stands disposed of, then nothing remains of this appeal.
Lordship, but I'm in view of this 16th October 2020 order. In fact, everything has been disposed of. It's only a
Mr.
cancellation.
Chakraborty's mother passed away, my lord. Let this matter be kept after vacation, my lord.
Why? If it can be disposed of, why after vacation?
My lord, this
Lordship, 16th October, court said to reconsider. It's only a rejection of my trade license application, enlistment.
There is no 16th October order.
Lordship, 16th October 2020.
Nothing in our file. দেখো কি বলছেন উনি।
APO 110 of 2020, Lordship. 16th October. Now, order to the. দেখুন তো আইপি মুখার্জি সাহেবের একটা অর্ডার ছিল।
When was the writ petition disposed of?
Not disposed of. Only interim order refused in the
Writ
month
is
of
pending.
pending. So Lordship, in
Is pending. The interim order, which has no interim order granted, but against
দেখুন,
that, there is provision for granting interim
একবার
order.
জিনিসটা দেখো।
Yes.
Mr. Ghosh, we recorded an order on 5th October, just about a week ago. We recorded an order. Mr. Molloy Singh had appeared for the appellants.
Yes.
And we had said that we are told that the affidavits are complete in
No,
the
Lordship. So far as KMC is concerned, affidavit has not come. No, Lordship, but I want to point out in this matter, let me sum up by 2 minutes. Rejection of a enlistment order on 2 grounds. Pollution Control Board certificate was not there and some repair was not there. Now Pollution Control Board certificate is there because that time it was not operational in 2020. In view of 10th October, in view of 16th October 2022 20 order by this appeal court.
Give us a copy. Kigo.
Lordship, I'm getting it in my.
Achona.
I have a net copy, Lordship.
Huh?
I have an internet copy, Lordship. I'm getting it.
The file matter to একটাই।
Justice IP Mukherjee and Justice Nijamuddin on 16th October 2020.
বার করো।
16th October
Record তো
2020.
রাখতে হবে ফাইলে।
APO 100 and
respondent 7. Department.
Lordship, what I'm saying is, since the situation has changed, we can jolly well approach them afresh. That was the order of 16th October 2020.
Oh.
So that's what I'm saying. 16th October, Justice IP Mukherjee and Justice Nijamuddin give us the.
Then what you are suggesting, we can not only dispose of the appeal, but also the writ petition.
Writ petition stating that that order has no more in force. We
Respect of that order of the victim, the matter was decided and an order was passed. Exactly, it's not with me, I cannot entirely do, but order has been passed, I know. And then matter, my lord, once we are before my lord, the victim is decided about my lord, Mr. Banerjee.
Lordship was also there. Lordship and presided by Justice Banerjee, order was there. Then they said you can shift the enter.
Mr. Banerjee, I remember absolutely nothing of the matter.
No, as per their
No, Lordship,
let us.
then Lordship kindly take some.
No. Just please give us. Let us get a printout of Justice
What I was
Mukherjee's
only
order.
saying is, whatever, done, not done, everything. It is a everyday renewal cause of action. I can place afresh, keeping those defects removed. I was not granted, say, point 1, point 2. There was 2 points on which I was refused. If I can rectify those 2 points, I can file afresh. They will consider me afresh.
File afresh.
So this will end to a litigation.
File
They can again reject me.
Not you. Not you, your application. How
Yes,
can they reject you?
Yes, Lordship. Yes, Lordship. Always pleasure appearing before your Lordship.
Let this matter appear on 16. Let me go through the entire paper, then I can appreciate
No.
for what is the present situation, what was being done at your end.
No, Lordship, what I'm only saying is let's proceed with the view that you have
I don't have
rejected
any
me 30 times. But then I can always renew my prayer. That's what I'm saying, that I will renew my prayer.
For adjournment on the ground of passing act of mother.
Yes, yes, yes,
Okay.
ma'am. Yes, ma'am.
What Mr. Molloy Singh had appeared for the appellate.
Yes, yes, yes.
No, I'm
Yes,
not
change brief.
You are appeal change brief then?
Change.
Lord, I am for the respondent number 7.
No, no. He's for the
He's the owner.
Owner of
owner
the
of the
premise.
Condition of the building is not as such. The condition of the building is
My
not
lord, they
as
have
such for
suffered
antimony
degree.
enrichment.
They have lost the appeal, my lord. Nothing remains, my lord. My lord, kindly after hearing, my lord, my
There are
senior,
a
my
lot
lord,
of facts that
an
there,
order may be
eviction
passed, my
is
lord.
there. And the eviction degree was also passed.
Informal paper book you have not filed.
Appeal reject.
No, Lordship, probably.
Very well. Come back. Come back on Monday.
Eviction degree was there. There are other issues, building collapse. These are the facts
Mr.
are there.
Ghosh, what he is saying makes sense. What he is saying is you had rejected his application for certificate of enlistment on grounds ABC. Now he says grounds ABC.
You will file again afresh.
Yes.
He's asking for.
Yes.
If the reasonings for which one it is been rejected, that still persists, then there is no question of
Yes,
or considering that application
true.
once again.
You are right.
Once again rejection. That is
Find that out because he is saying those reasons are do not persist anymore. That is exactly what he is saying.
Then even if it exists, then he will reject me on the same ground.
My lord, they have suffered decree in the year 1997.
Useless. Why? Let him find out. Likho. Mr. Ghosh, a learned advocate for the corporation, seeks a little time to obtain better instructions in the matter. Stop. This matter has paragraph lekho. This matter has been listed after quite some time. তারপরে ওটা যেটা বললাম লেখো, তারপরে next লেখো, let this matter be listed once again on October 16. Come back.
My lord, may it be 17, my lord.
17.
Yes.
October 17.
My lord, I am on behalf of the petitioner. Affidavit in opposition has been served. On behalf of the respondent number 9. And for the case. And by the KMC only yesterday.
Sir, I am appearing on.
Respondent 5 and 5 to 8. They have not submitted any. Take the microphone. My lord, I am on behalf of the petitioner. The respondent number 9 has filed the affidavit in opposition. But respondent number 5 to 8 has not yet served anything. And the respondent 1 to 4, state respondent, they have served affidavit in opposition only yesterday. So, my lord, if we be allowed time to file a reply and pending that, my lord, our prayer is that the private respondents number 5 to 8 may be restrained from dealing with anyway with the property on the basis of this wrongful entry. My lord, in this connection,
Your Lordship, I am appearing on behalf of respondent number 528. Your Lordship, I am led by Mr. Gunjan Shah in this matter. There was a direction for filing affidavit in opposition. But Your Lordship, due to want of some document, we need some more time to file the same. As such, I am praying kindly give us some time to file the same.
2 minutes, 2 minutes.
KMC has filed their opposition, Mala. This is his buttons to Mala.
Oh,
Sufficient wrong recording, Mala, as per their in the assessment. We have found our inspection book and we have disclosed everything in our affidavit. So, Mala, question of Mala stay or injunction, Mala. I don't.
In fact, my lord, KMC has corroborated our allegation that our allegation has been confirmed.
yes, why it was direction was given on 14th September, 1 month ago.
Ship, due to some relevant documents couldn't find.
That's a vague submission you are making. Where at 1 week after vacation. Issue.
Sir, my affidavit in opposition be taken on record, madam.
Affidavit in opposition filed on behalf of the respondent number 9. Who are you?
I am for the KMC.
Respondent number 9.
Find our affidavit in opposition.
You have filed. When? Salilekho, affidavits in opposition filed
Not
on
yesterday
behalf
only.
of
KMC.
on behalf of Kolkata Municipal Corporation and the respondent number 9.
I'm just looking what the second that is called, madam.
Me,
It is not available. Madam, in court.
Kolkata Municipal Corporation is taken on record. Stop. Paragraph. Learned advocate for the respondent numbers 5 to 8 prays for extension of time to file affidavit in opposition. Stop. Direction for exchange of affidavits was given on September 14, 2023. Stop. It is not appreciated as to why even till date the affidavit of the respondent numbers 5 to 8 is not ready. Stop. Paragraph, however, for the ends of justice, we peremptorily extend the time to file affidavit in opposition till 1 week after the ensuing puja vacation. Date diye dao, bracket. Stop. You can file later, no problem. We are extending the time. Stop. Reply thereto, if any.
My lord, both
Replies
affidavit
to
in
the
opposition corroborate.
affidavits.
Both the affidavit in opposition from the KMC and from respondent 9 corroborate our allegation.
You don't want to file reply?
My lord,
Do you wish to file reply or you don't want to file reply?
we will file reply.
Replies to the affidavits of the respondents, if any, be filed within a week thereafter. আবার তারিখটা দিয়ে দাও। হ্যাঁ, 23 হচ্ছে আর 30 হচ্ছে। Paragraph lists the matter once again on December 1st December.
Good.
Mr. Ghosh, maybe they are not interested to 2017 appeal.
Yes, right. And well, I find my cross objection is also there. As I remember, my lord, that nothing remains in this case. And if the appeal, my lord, goes, my lord, of course, my lord, my cross objection may not be any necessity, but I will look into it. Illogically, either.
Mr. Banerjee is for whom? Corporation. We'll dismiss for default the appeal See, the cross objection will be listed on Monday.
My lord, after vacation, my lord. kindly-
Mr. Ghosh says nothing probably remains, Mr. Banerjee. Dispose it off.
হ্যাঁ আরে তুই
ডিসমিস হচ্ছে তো
কি
আপনি ডিসমিস হচ্ছে
ডিফল্ট কালকে দৌড়ে আসবে 17 রেস্টের পর কি
ক্রস অবজেকশনটা 6 তারিখে রাখো
কোথায় ক্রস হচ্ছে আমরা তাহলে অ্যাপিল করেছি রে। হ্যাঁ দেখ তেরি ঘন্টা
ক্রস অবজেকশন না
হ্যাঁ অ্যাপিল তো ক্রস অবজেকশন
আমরা অ্যাপিল করি
জানি ওটা রেগুলার অ্যাপিল regular appeal. Why do you say cause objections? Cause objection, cause appeal and appeal quite different. Problem আছে আমাদের পার্টটাও চলে যাচ্ছে তো but actually we have also paper on appeal. This is regarding fixation of compensation.
5 নম্বরটা usual ইয়ে করে দাও, dismiss for default.
This is my lord. If it is dismissed, my lord,
Yes.
then naturally, my lord, so far our appeal is concerned, that is also challenging the same order, part portions. Kindly clarify that, my lord. The appeal which has been prepared by corporation.
Not clarify anything, we'll keep it on Monday. Mr. Ghosh said keep it on Monday. He wants to consult, look into the papers and find out if anything survives in your appeal in view of the fact that the other appeal is dismissed.
Very well, my lord. Since Mr. Ghosh is taking the responsibility, no problem, my lord. He'll take care of.
Dismiss for default, 5 নম্বরটা, 6 নম্বরটা লেখো। ডিফল্ট লিখবে না, 6 নম্বরটা লেখো। This appeal is directed against the same order which was under challenge in APO 554 of 2017 at the instance of the writ petitioners.
No, corporation. Or original application.
Stop. In today, that appeal being APO 554 of 2017 has been dismissed for default. এখানে লেখো dismissed for default. However, Mr. Banerjee
Assisted by Mr. Roy. Ghosh.
and Mr. Ghosh, learned advocates appearing for the appellants in this appeal say that this appeal may be listed on October 16 to enable them to consider if anything survives in this appeal in view of dismissal of the other appeal.
Very nicely clarified. I was a little bit anxious. Now it is clear.
Paragraph, let this appeal be listed again on October 16. 17 করো, 16 না করে October 17 করো।
May I leave, my lord?
এখানে কিন্তু না, interim order if any stands vacated. হয়ে গেল? ঠিক আছে।
Passed, my lord. Day before yesterday's server, so my lord, I'm moving it.
When should it be listed?
My lord, Monday, if your lordship, my lord, kindly.
Serve, serve.
Yes, sir. So,
No sanction plan or deviation?
no, my lord, deviation, and my lord, no notice given to me, despite the special officer building recording that he is the recorded owner. Notice given to erstwhile landlady.
Recorded owner?
I am the purchaser of the flat, developed. My lord, the
Mutated?
mutation in my name, 2017-19 mutation in my name.
Maybe one of the better cases. We'll
No, my lord, I believe so. Well, I sincerely hope so. And in fact, I was enjoying an interim order thereafter, my lord. I'll
Appellate side daily list item number 2, 3, 4. Item number 4.
This has become infructuous. Right?
4.
Yes, your lordship.
Yes.
It has become infructuous, your lordship.
Infructuous. Learned advocate for the appellant says that this appeal has become infructuous, paragraph. Accordingly, this contempt application, this application has become infructuous, paragraph. Accordingly, CPN such and such is dismissed. Is disposed of.
5, 6, 7.
My lord, the contempt application become infructuous.
Same order. Interim order if any stands vacated.
8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23.
Item 23, I am for respondent number 1, my lord.
Pass over.
24.
Mr. Yes. Pass over.
25.
Item number 25, lordship, Mr. Rajiv Mukherjee is appearing for appellant Bhatpara municipality. The same order may be passed, lordship.
Same order, we know, yes.
25 to 27. This was the respondent number 1.
Very well. ওই কালকে যে অর্ডার গুলো কে করেছিল আইডেন্টিক্যাল অর্ডার হয়েছিল দেখে নাও না ওই তো দিচ্ছে খালি নাম নম্বর এইসব পাল্টে 25 to 27.
Yes, lordship. In item number 28 to 30, lordship, Mr. Rajiv Mukherjee is appearing for respondent Bhatpara municipality.
Pass over.
31, 32, 33.
33, my lord, I beg to appear for the respondent number 6, 7, and 8.
My lord, not today. The advocate has been suffering from.
Sir, the microphone. Use the microphone, please.
Prayer for not today.
Use the microphone.
Prayer for not today. Record on advocate has been suffering from fever.
Not today.
Submission, my lord, I have not pursuant to my lord's order. My lord has been pleased to pass an order, my lord. My lord, the municipality, my lord, acting on the order has passed an order of demolition. And they have fixed the demolition exercise to be carried on 7th of November.
Tomorrow, he's asking for only 1 day's accommodation.
Grateful.
34.
34, my lord, I beseech your lordship, I am appearing for the appellant, my lord. My lord, due to some diagnostic continues for my health issues, my lord, I cannot appear before your lordship. If it is humbly pray before your lordship that the matter kindly keep after the vacation, my lord.
Very well. On the prayer made on behalf, learned advocate for the appellant, appearing virtually, appellant says that he is indisposed. Stop. On his request, let this matter stand adjourned. and be listed again on November reopening day.
My lord, kindly on 26th or 27th.
November 24.
My lord.
But I'm told Mr. Alok Ghosh is appearing for the corporation.
We say nothing.
35.
35, I am for the respondent society.
I'm grateful.
Pass over.
Second call, item number 2.
Usual je old matter guru hai.
Three. 5. 6. 8. 9. 10. 11. 12. 13. 14. 15. 16. 17. 18. 19. 20. 21. 22. 23.
Because I'm appearing for respondent number 1.
Appellant chilo na?
I'm for the appellant.
You are for the appellant.
I have such a. Sit. My lord, my respectful submission before lordship.
It was your writ petition, Mr. Bagh. It was your writ petition.
It was my writ petition, my lord.
My lord.
Let us read the order once, Mr. Sengupta. Allow us to read the order.
The order is at page 78 of the state petition.
Is there a delay?
No, my lord.
Why 2 applications?
My lord.
Why 2 applications?
One application for leave to file.
They were not parties, my lord, in the writ petition.
Oh, they were not.
They were not. That's the reason, my lord, leave to appeal. Also, my lord, there is a factually incorrect statement made in the, my lord, state petition, which I'll indicate once my learned friend makes his submissions. Because this application was not before the honorable court when, my lord, the order was passed. So they have pleaded that although we had filed an application and the application was pending for addition of party, this order was passed by the honorable court. It's an election process which is an issue. You know, the direction is the election process be concluded within a period of 3 months. This appeal, my lord, essentially is a stay. What they're praying for is a stay in that election process for the reasons which they have.
Let us read the order.
Lordship.
Yes.
My lord, at the time of calling, my lord, although application was affirmed and placed before lordship, allow me to intervene the application as an additional party, as interested party. But that time, I have not been allowed, my lord. By this time, on my presence, learned friend knows that order has been passed. Only taking the advantage as a normal order passing the honorable
single bench, that election to be held on such and such date, without considering all the facts and circumstances why the election is going on. My lord, my respected submission before received, appellant contention is this. That Odisha District Central Cooperative Bank.
Who are you?
I am a member of a primary cooperative societies whose representation has not been given to the District Central Cooperative Bank. District Central Cooperative Bank is a two-tier process, my lord. District Central Cooperative Bank, member of this District Cooperative Bank is a primary society.
Is there a cooperative election tribunal?
No, my lord.
Are you aware?
Election Commission is there.
There's the election commission, my lord. Our challenge is also against the inaction of the election commissioner. So we could not approach the election commissioner, my lord. Because the issue was, my lord, a draft list was published, voters list. My lord, after the publication of the draft voter list, an objection was, my lord, called for. Whether any party who is interested would have any objection. Objections, my lord, were put forth. Objections were considered. They were, my lord, disposed of. After that stage, my lord, nothing was happening. So the next stage was publication of the final voters list. That was not being done. So my lord, the writ petition essentially was with a prayer that there be a direction that the final voter list be published and the election process be concluded within a time frame. That was the limited relief, because the board's tenure was coming to an end by the 16th of September of the cooperative bank. 15th of September.
Before a lordship, only for statutory violation, my lord. Central Cooperative Bank, member of the Central Cooperative Bank is the primary cooperative societies.
Use the microphone, Mr. Sengupta.
Hello. My lord, the District Central Corporate membership of the District Central Cooperative Bank is the primary cooperative societies. No person can be a member of a District Central Cooperative Bank. The District Central Cooperative Bank membership, primary societies, the election of the District Cooperative Bank is going to be held. There is no objection. I am not standing away of holding election. But to whom the primary election represented by delegate convoking representation, that election has not been conducted. If primary cooperative societies election has not been conducted or are dormant, then how the primary cooperative society will send representative to the Central Cooperative Bank for election of that cooperative bank?
Have you made this, have you ventilated this grievance before the election commission?
My lord.
Have you ventilated this grievance?
My lord, not in that time, because my lord.
Do that.
My lord, my submission, your lordship. I am not against the holding election.
Whatever, why should we interfere? The learned judge has passed an order to
my lord, statute.
Make your representation before the election commission. They'll consider it.
My lord, if I go to the commission
Yes.
and say that the government of cooperation department hold an election by sending the board of administrator, then and there they will say it is not our business.
We don't know what they are going to say. We can't speculate. We can't anticipate.
My lord, but my respectful submission, my lord. How the election can be conducted is it section 36 already complied with. My lord, the election can be held. I am on the election, my lord.
Mr. Sheikh,
I am on the election. I am not.
There is nothing before us to show that you argued all these points before the learned single judge.
My lord, election commission, how will adjudicate, my lord? I have no grievance against the election commission, my lord.
Nothing before us to show.
I have no grievance against the election commission, my lord.
My lord, may I also submit this? This was not submitted before the learned single judge, my lord.
Could not get a chance.
None of these submissions came forth. Also, my lord, these submissions do not have any foundation. I can show from the.
Was your application in the list?
No, my lord.
Then
it is not.
I only in my.
You can't just take it like that and give it to the learned judge.
Prayed, my lord. Only liberty.
Rightly refused. You should have filed it earlier and should have got it listed, Mr. Sengupta. If you want, you can go back before the learned judge with whatever application you want to, but we are not interfering in this.
Very deeply objective. And that's the wrong, my lord, recording, my lord, the pleading which my learned friend has made at page 5, the first 3 lines. My lord, of the state petition. Where it has been, my lord, page 5 of the state petition.
Which can?
My lord, this is can 2, my lord. Can 2 of 2023. First 3 lines.
Yes.
My lord, it is pleaded that they have filed an application in the writ petition being 21517 of 23 for addition of
Paragraph?
party. This is the first 3 lines of the page. Paragraph 4 at page 5.
Oh,
The first 3 lines. Member Cooperative Society have filed an application in the writ petition being so and so for addition of party wide can 2 of 2023, but the same was not taken up for hearing, and the Honorable Court, even after hearing the party simpliciter, directed for completion of the election.
so you are saying their application had not been filed?
It was not filed. In fact, that is also admitted by my learned friend.
Then why is this statement made?
My
Mr.
lord,
Sengupta?
unconditional apology, I have been reported that file has been completed. I am paying unconditional
It was
apology.
not there before the court.
I am paying unconditional apology on that.
This is casting an aspersion on the learned judge.
That's the reason, my lord, I indicated.
With a hand, I have given my lord, give me leave to file this application.
Go wherever, no issue. Can one to know again. This is an application for leave to appeal against a judgment and order dated September 12, 2023, whereby the writ petition of the respondent number 1 herein, being WPA 21517 of 2023, was disposed of by a learned single judge of this court. Stop. কি বললাম? হ্যাঁ, ঠিক আছে. Stop. The paragraph. The applicant says that he is a member of the concerned cooperative society and is accordingly affected by the order.
He's a member of Dinanagar Samabai Krishi. That's
a private society.
That's a private society. It's not the
Private, primary society.
Primary is PCS, my lord, but this is in,
how do you
in paragraph.
Repeat.
It's Dinanagar Samobai Krishi Unnayon Shomiti Limited.
Dinanagar Samobai Krishi Unnayon Shomiti Limited, a primary credit society. Stop. তারপরে কি বলেছি? Member of a
rejected
concern হবে
sorry
না,
lordship, I'm
নামটা চলে গেল.
bit late, my lord. I am
কোঅপারেটিভ সোসাইটি কোথায়? নামটা দিয়ে দিল তো আবার. হ্যাঁ, সমবায় অমুক তমুক. By the order impugned. Stop. The learned judge has directed completion of the election of the Board of Directors of Nadia District Central Cooperative Bank Limited without first ensuring that, what is your grievance?
election of the primary cooperative societies had not been completed.
Without
Those were
ensuring
the
that
member of central
election of the primary cooperative societies
not been completed. As a result,
are
we cannot
completed.
represent.
Are completed. Stop. Paragraph having heard learned counsel for the parties, we are of the view that the applicant may have something to say as regards the order he seeks to challenge. Stop. Accordingly, leave is granted. Stop. Can 1 is disposed of. Mat and can 2. The writ petitioner, the respondent number 1 oblique writ petitioner, had approached the learned single judge with the grievance that although the tenure of the Board of Directors of Nadia District Central Cooperative Bank Limited, bracket lekho, the bank, in short, the bank, bracket closed, was to expire on September
15,
15, 2023, And although draft voters list has been published and objections thereto have been invited and considered, comma, the final voters list had not been published, with comma, without which election could not be held. Stop. The learned judge disposed of the writ petition with the following directions. Internal page 2. Paragraph. The appellant says that unless the election of the primary cooperative societies is first held, comma, the election of the board of directors of the concerned bank cannot be held. Stop. The appellant has made a statement in paragraph 4 of the stay petition, bracketed can 2 of 2023, comma, to the following effect, colon diye quote karo, the petitioner states that being a member of the cooperative society, capital A cooperative society, have filed an application in the writ petition being WPA 21517 of 2023 for addition of party, Vide Can 2 of 2023, but the same was not taken up for hearing, and the Honorable Court, even after hearing the parties simpliciter, directed for completion of the election of the District Central Cooperative Bank Limited within a period of 3 months. 3 months from the date of communication of the order capital, without considering the contention of the petitioner, that election of the district bank capital, without convoking,
Delegate convoking, delegate.
without convoking,
That's the term they use.
convoking, CONVOKING, delegates from elected bodies of primary member societies, primary capital, societies capital, shall be void, comma, illegal, and in violation of the provision of the statute. Stop, unquote. শোনো, আমি এখানে মার্ক করে দিচ্ছি স্টে পিটিশনটা, দেখে নিও, বিরাট সেন্টেন্স তো, আর আমি ব্র্যাকেট করে দিলাম, যেটা হবে সেটা আউট হবে, মানে কোটেশন হবে। Paragraph. Mr. Bagh, comma, learned advocate appearing for the respondent number 1 herein, says that the aforesaid statement is incorrect. Stop. No application had been filed by the present appellant before the learned single judge. Stop. Paragraph. Mr. Shengupto, comma, learned advocate appearing for the appellant, comma, in his usual fairness, comma, says that Mr. Bagh is correct. Stop. The application was sought to be moved unlisted, but the same was not allowed. Stop. He tenders apology on behalf of the appellant for having made a misstatement, for the appellant having made a misstatement as aforesaid. Paragraph. we are not inclined to interfere with the order under appeal. Stop. The appellant's application was admittedly not listed before the learned single judge, and in fact, we are told, comma, had not even been filed. Stop. Hence, comma, there is no reason why we should entertain the present appeal. Stop. Paragraph, however, the present appeal, which is accordingly dismissed along with the connected application. Stop. However, this will not prevent, with a paragraph, the appellant from pursuing such other remedy that he may have in accordance with law.
Very deeply obliged, my lords.
Since we have not called for affidavits, etc., etc.
Deeply obliged.
Get But I was a bit late, Lordship, to attend the hearing. This is all right, my lord. I was appearing with the election commission. Election process is going on. I'm deeply obliged.
Dispose of যেটা লিখতে হবে, কারণ আমরা কোনটা লিখবি?
My lord, I appear for the writ petitioner, my lord.
I am for the municipality, my lord.
Appellant?
I'm for the.
My lord, before my learned senior friend begins, my lord,
So all parties served affidavit of service
Earlier occasion.
earlier.
my lord, before my learned senior friend begins, my lord, I am being led by Mr. Suvashi Sen Gupta in this matter. My lord, he's in some difficulty. I was praying for a knot today.
Not today.
Monday.
Monday?
Monday হবে? কাল করবেন? আমার কোনো আমার emergency আছে। Without serving the copy of the notice, it has been moved and I came to know subsequently.
Accommodation is prayed for on behalf of the respondent oblique writ petitioner.
Yes, my lord.
Stop.
And municipality has already been taken.
Paragraph.
Hearing, my lord.
List the matter once again on October 16, retaining its position.
Deeply obliged, my lord. 16.
Monday.
Lordship, I'm appearing for respondent number 1.
Yes, madam. 28.
I'm for respondent number 1.
Nay, state. Chiluna. That's the usual order. Give your appearance.
Similar, Lordship.
Similar order.
29:30.
Similar order.
30 similar, Lordship. আর যায় হ্যাঁ
31. But I am for the appellant.
I am for the Bali municipality led by Mr. Banerjee, my lord, in this matter. Last occasion, Mr. Banerjee submitted that we have filed the cross objection in the matter, my lord. We have filed, but it is not listed. Yesterday we have filed, we have served the copy. This is the court.
You supplied the number.
This is the first number. Yes, I have.
Give the
supplied.
number.
Yes.
Tomorrow it will be listed. Monday.
After vacation.
Huh?
After vacation, as you.
After vacation. Learned advocates for the parties jointly submit that this matter may be taken up after the ensuing puja vacation. Stop. Let that be so. Stop. Let the matter be listed on reopening week on November 16,
Along with the appeal, cross appeal.
2023, along with the cross objection that has been filed by the municipality being COT.
90 of 2023.
Pecho.
Great, your lordship.
ছিল না তো যা দেখ বলে দাও না থাকলে যা হবে Your
Society.
appellant was not there in the first call also.
Yes, come.
He's come.
Yes.
Where is he?
And talk to me. Yeah. Kindly short pass up
Who is appearing for the appellant?
for the Devranjan Banerjee. Shubhadipto, hey.
In person?
Sumitavo Chakraborty.
Was he there in the first call? Peter.
Yes.
But on the last occasion, my lord, we have sought for leave to file an application.
FMA, what is the subject matter of this?
It's a mandamus appeal now being numbered as FMA.
No other party, only Devranjan and Srimati Arati.
My lord. And the cooperative society is a party, my lord.
Oh.
I've served all of them, my lord. I've filed the affidavit of service.
Oh. A chamber matter.
She died, my lord.
But then you have to start from the beginning, Mr.
We will start from the beginning.
Because my brother was
Yes.
not a part of this bench. হ্যাঁ ঠিক আছে চলো না
I'll start off with the order impugned, which is 192 of your lordship's brief, my lord, page 192. My lord, I'm being led by Mr. Mithro, my lord.
Repetition.
Is there a new application which has been filed?
Yes, because we wanted to perform the last rites of the mother where the last rites of the father was performed. But that has become academic because yesterday was the date and we did it in the Ganga Ghat.
Then what remains of the application?
No. The other prayers are there, my lord. Now, what has happened is, my lord, under the deed of settlement, your lordship perhaps has seen that the mother had.
No, what we are suggesting, Mr. Mithro, these papers are unmanageable. Why don't we hear out the appeal after filing an informal paper book?
We had filed an informal paper book.
Where?
With the index. Please, this is the index,
হয়ে গেছে এখন আর
paper, the
এসব
stay
চলবে।
petition was filed,
গতকাল ছিল হয়ে গেছে
contains all the papers. It contains all the papers.
Sir, paper book to respondent file করেছে।
Paper book is not filed.
File করে দেবো আপনাকে।
সেটা করতে
No, I'll file it if the respondent has, I'm the petitioner, I'm the appellant.
But they chose to file it.
No, I'm the appellant in the appeal. I'm the appellant in the appeal. The respondent chose to file the paper book. If they haven't, I will file it after vacation.
The respondents said they will file the paper book.
Yes.
Which order is that?
Respondent paper book file করবে
I have
কোথায়?
not received. Respondent নিজেরাই file করেছে।
They had filed the paper book. There is no order, but they had filed the paper book. You know, we have got the paper book. কি করছো তুমি?
Sir, আমরা file করবো।
Well, we will file the paper book after the vacation.
File
But
it.
in the meantime, let the registrar cooperative societies, because your lordship has seen the deed. It says that the father was the owner, he took a loan, and thereafter he paid back the loan, he got the flat in his name and got it mutated. He gave his wife the life interest.
No, Mr. Mitro, kindly come from the beginning. My brother was not a part of that bench.
Yes.
And I have also forgotten. Justice Kaushik Chando was a part of that
Yes,
bench.
yes. And then they went to Justice I.P. Mukherjee first.
That I don't remember.
Yeah.
So you please treat us as absolutely new to the matter.
Yes, my lord. As I treat myself also.
And you are. You were not appearing before.
No, I appeared before Justice Banerjee. না ওই 23 নম্বরে কি ছিল? Justice Arindam Mukherjee and Justice Vishwanath Samadar.
Live streaming হচ্ছে।
Justice Vishwanath
Hey,
Samadar.
Pause করো তো। Live streaming টা pause করো। এটা কি দেখাচ্ছে?
আমি এটা
Yes.
And your Lord, your show is recorded. They resolve the disputes amicably. The appellant without prejudice offers the following. Appellant will go on paying 10,000 per month as maintenance. Appellant will bear all the medical expenses. This appellant will pay the quarterly maintenance charge of the cooperative society, which I'm not really obliged to, but I took it upon myself to pay the cooperative society as well as property tax with regard to the flat in question 17 lower range. Appellant also agrees to the right of residence of the respondent number 1 for the rest of her life. That is all right. Then respondent number 1 offers that the appellant will have uninterrupted access to the flat in question at all time because I'm the beneficiary. I'm not going to live there, but I should have access. Then she will not create any third party interest with regard to the flat in question during her lifetime. That was the main thing. So that I get my beneficial right whenever I get it. Then, my lord, the next order is, we are today informed by learned advocate appearing for respondent number 1 that the respondent number 1 is not agreeable to the proposal. That was given. So, my lord, she gives the proposal and then resigns. I was willing.
Wait, come back on Monday. Come back on Monday.
There's someone else behind. The cat's paw is there. Now that she's gone, the cat's paw, I don't know what role it will play.
What was the mother's name? Shunda? Na.
Aruti.
Aruti.
Aruti Banerjee.
I was close. Shunda Aruti. So.
Shunda Aruti, yes. Now the pujas are coming, it becomes more relevant.
36.
I'm grateful.
I am appealing for the applicant.
Yes.
Matter, Your Worship, kindly adjourn it for Your Worship.
You are for the applicant.
I am for the applicant. Malad, only part of the Your Lordship's order, Malad, I am praying before Your Lordship.
Who was the appellant?
Malad, appellant, my learned friend appellant. You may remember the review application.
We had disposed of the appeal by directing you to go before the tribunal.
Yes, 218(3). Yes. Thereafter,
Tribunal is not there.
There.
So you filed a review. We allowed the review.
No,
This is the second.
No, tribunal is there, but order passed by the chairman. For that reason, Your Lordship modified the order.
Board of Council.
Board of Council, it should be passed by the Board of Council, the demolition order, but the order has been passed by the chairman. For that reason, in the review application, Your Lordship set aside the order. First, Your Lordship decided the issue and sent back my learned friend to.
Show us the order under review. Which page?
That is page 77 onwards.
Well, actually,
Page 77 and page 78.
Allow us to read the order.
কত পেজে দিয়েছো? কত পেজে দিয়েছো? এ করেছো কেন?
Oh, the order under appeal was set aside because it was passed by the chairman and not by the board of councillors. Yes, this is the order under review in this application.
Yes.
Why?
Malad, because the third part, malad, third para of 78, page 78, third
Yes,
para.
yes.
Learned advocate for the private respondent number 9 says that direction should be issued on the municipality to initiate fresh proceedings against the review applicants in respect of the impugned construction. We are not inclined to pass any such direction. The municipality is left to its wisdom to take appropriate steps in accordance with law.
Yes.
Malad, I am only praying, let it be, instead of wisdom, let it be direction to initiate fresh proceedings. Because there was a, Malad, in the year 2020, I filed a written complaint with allegation they are unauthorized construction. Order has been passed by this Honorable High Court in the year 2020.
Madam, we rejected your prayer.
that was not challenged till date. Well, that order still subsisting. And the construction made by my learned friend is, my lord, all the authority detected that is unauthorized without any sanction plan. So I am praying before all lordship that fresh proceeding may be initiated by the board of councillor. And upon opportunity of all the parties, hearing must be done and let a order passed by the competent authority.
Which order is subsisting, you said?
My lord, that is page, if your lordship kindly say, that is page 30.
Which from municipality? Which from municipality?
30 is no order. Municipality has been served.
My lord,
You are
that
for the
is
municipality.
32. That is first writ application filed by me. With allegation the unauthorized construction made by my learned. Page 32. My lord, this is mistake page 33, another page annex. My lord, this is my I paying
Mr. Chakraborty, what she is saying is that in our order, whereby we allowed the review application of the appellant, setting aside the demolition order, only on the ground that the chairman had passed it and not the board of councillors. In that review order, she had prayed for a direction on the municipality to initiate fresh proceedings. Now, we had said, no, we will not pass any direction. We are leaving it to the wisdom of the municipality. She now says, this is the second review application for review of our order passed in review. He now says that there is an order of a learned single judge, Justice Boshak. Come to page 32. Page 32. This directs the municipality to initiate proceedings. But madam, the demolition order that was passed was after this order was passed, pursuant to this order. So this order has spent its force. Now all we will say, if Mr. Chakraborty, if illegal construction has been detected by the municipality, you must proceed against it. We are very strict about that. You know that better than anybody else. Mr. Shah, if we have left it to the municipality, we will reiterate that in the event.
Probably, my lord, no order, with my respectful submission is no order should be passed, my lord, modifying the order. Your lordship, I am led by Mr. Sandal, my lord. There is no
application after 1987 Supreme Court in a disposed of matter with a prayer like this is not.
This is not a review.
Not review.
No, modification.
Modification of the application.
Modification.
You are
asking now, direct them to do it.
You are referring to Brahmodat? No.
Yes.
87 Supreme.
1987. If I'm not wrong, page 135 or 153. But this sort of application is not.
In everywhere, my lord, report, municipality report, BLLRO report, my lord, everywhere that was detected the unauthorized construction. And my lord, that is, I am saying, if there is wisdom, my lord, their wisdom they take into consideration or not. My lord, direction may be given to initiate fresh proceeding upon opportunity all the parties. Because my lord, the municipality, my lord, detected 3 times there was a no sanction plan. And these honorable high court single bench 2 times, my lord, detected they are not.
We will reject the application. We will reject the application as not maintainable, but also observing that it is established law that if the municipality detects illegal construction, proceeding in accordance with law will be taken.
Yes, my lord, that is.
That's their. It's a repetition your losses.
Anyway, we have to reject the application. Now, what observation we make, we have to give it to us.
Observation, sometimes your losses amounts to direction.
We won't give direction, mind you. Don't. We won't give yes. Come back tomorrow. It for orders. Rekhe debe to godate ekdom. Godate for orders. Heard learned counsel for the parties. Stop. This matter under the heading for orders at the top. Kal ke date diye do.
And next matter, but both the parties are here. It can be after vacation. But no, not next. It is on 44. Number 44. Both the parties are here.
Yes, tell us, tell us. Sister Judge is waiting on the corridor.
1 week after.
44, 44, 1 week after vacation.
আরে দু জায়গায় মামলা করে একে সভ্যতার ঘরে 19 আছে 16 চলছে সেই 16 বলে এদিকে এখানে 52 আছে 8-এ 48 আমাদের মক্ষে বাইরে পয়সা দিচ্ছে তো ডাক ডাক পয়সা দিচ্ছে
আমরা তো ওরা প্রচুর হোয়াটসঅ্যাপ ওতে এটা আপনার সাথে দেখা করতে চাই চেনে নেবো না। হ্যাঁ
Side assignment matter item number 1.
My lord, in this matter, I am appearing for the petitioner review application maker. My lord,
My lord, may I have my lord's kind leave not to
Mr. Bhattacharya,
matter-
Mr. Vikas Bhattacharya is leading me, my
is very brief. But the petitioner before lordship,
Hmm.
lord,
Mr. Bhattacharya, we had listed this matter for fixing the hearing.
okay, kindly fix the date.
Uh, After, immediately after vacation,
Very well, very well.
this side of the vacation হবে this side of the vacation this side no no
yes, Mr. Bhattacharya.
But I have no objection.
On the, in the reopening week, if you,
My lord, kindly do this.
all these matters, are connected matters.
But I'm the
You can, since we have a few minutes, Mr. Bhattacharya, you can apprise us about the facts of the
Well,
case.
it's very short fact that the headmaster of a school who was newly appointed in a school, Millard, one of the other teachers who had been transferred, he says his transfer appointment was delayed because of some inaction on the part of the headmaster. The learned single judge ultimately passed a very drastic order and said that 3 persons who were found to be involved in causing delay in giving appointment to one of these teachers, they should be proceeded with and proportionate salary should be deducted from their own package. Now, this petitioner, his headmaster, in fact was not really involved. The learned judge thereafter said, no, very well, petitioner will get full salary, but will not act as headmaster. My situation is I am getting full salary. I am not working as headmaster. I have to go to school and sit like a doll and come back. This
Who
is
is
absolutely humiliation.
You are Sanjukta.
Yes.
You are Sanjukta.
I'm the writ petitioner.
Read petition. You are state. You are assisting Mr. Bhattacharya.
Yes,
Mr. Bikash Ranjan Bhattacharya.
Yes.
Very
What
well.
Mr. Banerjee has said, Malad, this is not the fact.
Very well. We'll hear the matter. Is the impugned order a very long order?
No, very short order.
No. Malad, the earlier bench, division bench, Malad, presided over by Justice Talukdar, Malad, has dismissed the Malad appeal, Malad, against which Malad the review.
This is a review. This is a review. Oh, the appeal was preferred by Mr. Bikash Ranjan Bhattacharya's client.
Yes.
Oh, I see.
Malad, his client has favored such a teacher who has cut her wife in 36 pieces.
No, that is not the issue.
Yes.
But
In
why
regard-
was
My sister was a party to that.
yes. That's why the other learned bench.
Pieces. It took
No,
10
was that
doctors
the-
Malad, to stitch the pieces, Malad, and do the postmortem.
Yes, you
But was that the petitioner's case?
And
I
knowing
didn't know.
fully well that he is such a culprit, Malad, I was prevented for more than 1 year by this headmaster.
No, let us not take up this matter then. 36 pieces?
Yes.
Released. Very well. Then 17th of November, Mr. Bhattacharya.
Milo.
এই দেখো বেঞ্চ করতে হবে তো
17th was a reopening. 16th of
হ্যাঁ 16th reopening
7, let it burn 17, Milo.
17th হবে roughly how long should it take, Mr.
No,
Bhattacharya?
I will not take more than 10 minutes. I can assure the worship.
And you 10 minutes, half an hour. We'll keep it for half an hour. We have our own benches. We'll keep it at 4 o'clock.
Malad,
Yes.
kindly cut at 2 o'clock.
No, not 2 o'clock.
No, 4 o'clock, irrespective of any other decision of the bar.
3:45.
3:40.
Milo.
3:45. These matters have been assigned to this bench by the Honorable the Chief Justice. Stop. So basically, it's one review application.
Yes, my lord. Yes.
Basically, it's one review application.
Yes.
Stop. Basically, it is one review application directed against a judgment and order dated.
Malad, the judgment and order dated. Just a second.
Blank. Passed in blank.
এই সৌম্য জাজমেন্ট অর্ডার ডেটটা বলো কি
Malad, kindly 11th of August 2022, page 38.
Passed in Matt,
596 of 2022.
whereby the appeal was dismissed. Stop. Paragraph. We have heard Mr. Bikash Ranjan Bhattacharya, learned senior advocate, representing the appellant / review applicant, and Mr. Anjan Bhattacharya, learned advocate, representing the respondent / writ petitioner. Stop. We have also heard Mr. Bari appearing for the state. Stop. Today there isn't sufficient time to conclude hearing of this matter. Paragraph. List these matters once again on November 17, 2023, marked 3:45 p.m. Thank you.
Malad, we sincerely hope, Malad, we can do this matter, Malad, before this bench.
It's very kind of you. Thank you.
Grateful.
I am praying for apology, my lord, because my lord 28, 29, 30, my lord, 24 appeal I have filed, my lord, gratuity matter, my lord. My lord, Mr. Siddiqui and me, my lord, engaged to continue hearing code number 11, my lord. Kindly, my lord, restore the
ওই
matter.
তিনটে করো না, ডিসমিস ফর ডিফল্ট 28, 29, 30।
Item number 37.
Lordship, I am for the appellant, Lordship. Lordship, I have filed an application for appointment of handwriting expert. Lordship remembers on the last occasion, Lordship, I started placing the judgment. My paternal grandfather, Lordship, executed a holographic
You
will.
have filed an application before us.
Yes, Lordship.
Have you served?
Yes, Lordship. I will file a affidavit in opposition against.
Affidavit. You want to file a? We have to give her an opportunity.
Lordship.
With the application to the
After vacation? Yes, 3 weeks after vacation.
3 weeks after Christmas vacation? No, after Puja vacation. All right. This application has been taken out by the appellant. To appoint a handwriting expert to compare the handwritings appearing in the three documents being Exhibit B, Exhibit 3 and Exhibit 1 in the records of the present appeal, which are also annexures B, D and A to this application, and to submit a report thereon. Paragraph, learned advocate for the respondents, all respondents, says that her clients would like to file an opposition to this application. So let affidavit in opposition be filed within 1 week after the Puja vacation. Date diye dao.
Who will pay the cost? Who will pay the cost?
No,
We will bear it.
she will have to pay her client. He will say.
Lordship?
Have you mentioned that he will pay the cost?
Lordship, at the time of moving this, Lordship, we will say. It's not indicated there, Lordship, but it is my application, we were ready to pay the cost.
The reply there too, if any, be filed within a week.
Lordship.
Thereafter, tarikta diye dao abar. Next, list the matter once again on December 4.
Grateful, Lordship.
First call.
Or is it first call?
This is the first call.
Very good.
39. 40.
Mr. Mukherjee has come to court. Second call, we'll take it up.
1. 42.
I am for the petitioner. I am for the petitioner. First one.
43. 45. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. Second call, item number 38.
So,
Nobody has it.
hearing matter before vacation, nobody will come also. We are here, there. We'll come.
The difficulty is, my lord, this.
Who is appearing?
My lordship, recall that the main answering respondent, the municipality, my lord, pursuant to my lord direction, and the matter has been.
Which municipality is this?
Boitobati municipality. One Mr. Vasudev Gayan appears, and my lord, though I shouldn't say, but the records will reveal that most of the time, my lord, this matter could not be taken up by your lordships because of non-availability of the municipality.
Can we pass any effective order without hearing the municipality?
My lord, each and every time he was served, even my lord, when lordship's pleasure was to keep the matter as specially fixed on the ground, my lord, that one person has retired, but he is not getting returnal benefits, and other person though was in service, but he, my lord, died, my lord, leaving her, my lord, a minor daughter and wife, and substitution applications are also there. And considering the fact, my lord, and his wife has not been given nothing. And my lord, I am also, my lord, seeking a parity, my lord, that with in view of the other employees, my lord, and also the judgments of the past by the honorable division bench. Now, this is the situation. That is why it also, my lord, took some consideration before the lordships, my lord, that to see.
So tell us what we can do.
My
We
lord,
can direct the chairperson to be present here, but how will that help? And that will put your learned friend in great difficulty.
I understand, but my lord, so far as my instructions are concerned, my lord, that the clients are also cursing on my advocate on record. Particularly, my lord, the persons who had died, his wife, regularly visiting the chamber.
So then you tell him once that if he doesn't come, your learned friend.
My lord, on the day before yesterday, my lord, the matter was taken up. Lordship may recall again, my lord, we intended to serve. Well, he was not available in the office. In the Dropbox, the letter was dropped. Again, my lord, in mobile, the WhatsApp, this message was sent.
Mr. Basu, we can do either of two things. Number one, we can record an order which is to be sent to the chairperson by our registry that time and again, if this matter has been called on, nobody has represented the municipality. On the next date, we will dispose of this matter ex parte. Or we can proceed ex parte and deliver a judgment, whichever you prefer.
I leave it to you, lord. This is also a very embarrassing, my lord. I leave it to you, lord. I only say, my lord, this position of the persons, lordship is always there. I know, my lord, either on the side, my lord, that lordship will hear the matter. But the difficulty is, my lord, that this is the situation. And my lord, going by ex parte, my lord, lordship may also know that a chance of review.
Issue. This Krishanu Moitra has passed away.
The substitution application is tagged along with the file. When my lord would hear it, my lord, that is also filed in time.
We can allow it here and now.
Lordships may or may at the time of final hearing.
Very well. This matter has been called on several times. Stop. The municipality has not been represented. Stop. The municipality's presence is essential for meaningfully proceeding with this matter. Paragraph. As a last chance, comma, let this matter stand adjourned and be listed on November 17, 2023. Stop. We understand that the appellant has passed away during the pendency of this appeal. Stop. His family is not receiving the death benefits.
Including, my lord, the scope of regularization.
receiving the benefits that are claimed, retirement benefits. Retirement
The
benefits.
moment, my lord, I would be, my lord, if my lord's allow my lord my appeal, then I would be getting eternal benefits along with my lord on basis,
Very
my
well.
lord, that all.
আচ্ছা আসছে না তো সেই। কি বললাম? Appellant has passed
My
away.
appointment was
No.
made on regular basis on a sanction post. And I was paid also,
No,
my
his
lord,
family.
permanent
কেটে দাও, কেটে দাও। His family is in financial difficulty and appeals to us to have this matter disposed of at an early date. Paragraph. We make it clear that on the adjourned date, on the next date, comma, no further adjournment will be granted, irrespective of whether or not the municipality is represented. Paragraph. The registry shall immediately send a copy of this order to the chairperson of Boiddobati municipality. Chalo. Registry ki to bollo? Registrar General. The office of the Registrar General Talakoro will immediately serve a copy of this, or serve a copy of this order on the chairperson of Boiddobati municipality.
The connected matter. That
Yes. So it got
only the difference because it is my duty that Lordship has recorded that the appellant has died. Here, my lord, appellant is present.
54টাও 17th হয়ে যাবে, অর্ডার হচ্ছে না কোনো।
He was only paid, my lord, 2 lakhs rupees up for the provident fund, but nothing. My lord,
Come back.
my lord, no date is possible before vacation. I understand.
This has to reach the municipality. They might make alternative arrangement, Mr. Basu. Some time has to be given because we are peremptorily fixing it. We are not going to adjourn it any further.
Then, my lord, may it remain also hard in part because my lords have given a peremptory direction. If I do not know, my lord, but if it,
Nice wristwatch.
I'm grateful, Lordship. And my lord, 17 is some, my lord,
Difficulty.
not difficult. It is a truncate, my lord.
18th?
No, your lordship.
Bolo, tell us.
My lord, after 21st onwards, my lord, any day convenient, my lord, to any day.
হ্যাঁ 22 তারিখ করে দাও।
Very good. 21st is the Jagannatha Pujo. Any day thereafter.
22 করে দাও।
I'm sorry, my lord, to say something. I'm grateful also. Both the matters will, but be tagged together also.
No tag. One is specially fixed, one will be normal.
I'm grateful also.
39.
আমারটা কোনটা?
Saturday.
Forward back.
Mr. Ratu, you will keep us occupied till 3:30?
I don't think so.
You don't think so?
Half an hour.
Half an hour. Because some of your learned friends are walking up and down the courtroom trying to assess.
Yes.
So for half an hour, everybody can go for half an hour.
Thereafter, if Mr. Sen takes over. Why not? Because of the last occasion, Mr. Sen had placed before your lordship that the relevant circular of the corporation and rule and the applicability of rule 142. The corporation, my lord, while according the sanction and in reply to our objection before the KMC, had said that the sanction was granted under section 393 and not under rule 142. Pursuant to that, my lord, we had challenged this order of the KMC by filing a supplementary affidavit before the writ court by filing Can 3 of 2021. This was done, my lord, pursuant to the leave granted to us by the Honorable Division Bench, which said that the corporation ought to have considered our representation made in 20th of January 2021, and therefore they should grant us a reasoned hearing and pass a reasoned order. And if we're aggrieved by that order, we can challenge that before the writ petition as well. So in addition to the prayers made in the writ petition, we had challenged the order of the KMC, which said that the sanction was granted under section 393 and not under rule 142. But a perusal of the impugned order would show, my lord, that in that order, no reference was made at all to the challenge thrown to the order of the KMC. This motion is totally left out as if it never existed. That has not been dealt with at all. And on the last occasion, my lord, Mr. Sen had placed before your lordship that rule 142 squarely applies by showing that the building is more than 50 years old. From the deed of conveyance, it was shown that the structures existed in that land even in 1933. And from the calculation of the total area of the land and the constructed area, it was demonstrated before your lordships that the FAR that they got was 2.91, which is much in excess of the permissible area of
2.25. So this excess FAR is granted only when the benefits under Rule 142 is given in order to accommodate the tenants. 100% additional area is given. Now, your lordship will also consider that the registered declaration that was given before the KMC mentioned that they had got a tenanted premises. But in violation of the guidelines given for the registered declaration, no particulars of the tenants were given. This I had placed, my lord, on the first day itself. A perusal of the registered declaration would show that no names of the tenants was given. The area occupied by them was not given, as is required to be given under the format under the KMC Act read with Rule 142. So these are the violations that were that took place during the sanction of the plan. Now, the lordship also knows that there was an order of the civil court. The initial order was not to disturb the peaceful possession of the area occupied by me. And thereafter, my lord, the decree was passed in my favor in respect of the entirety of the 5,000 square feet, declaring me to be the tenant. While the decree was passed, the first order of injunction that was given not to disturb my peaceful possession, that was vacated. So I filed an appeal from that ex parte decree. They also filed an appeal from that decree. In the appeal, an order was passed on contest, restraining the respondents from disturbing my peaceful possession over there, and also from changing the nature and character of the suit property. That order has been annexed. Kindly, your lordship has a look at that order, and that order was communicated to the KMC. That order is page 683, that is at volume 3. The first volume also.
First volume. Which page?
Page 43. 11 June 2019.
43 is a district judge's order.
The first appeal.
First appeal.
Injunction was passed in the first.
First appeal.
And this order of injunction continues even till date. Sorry, my lord, the photocopy is extremely 45. In view of this, the third last paragraph, this court is inclined to allow the prayer of ad interim relief of injunction in favor of the plaintiff, appellant petitioner, restraining the defendant, respondent, opposite party herein, and their men and agents from disturbing the peaceful possession of the plaintiff, appellant petitioner herein, and also not to change the nature and character of the suit property, and not to oust the plaintiff, appellant petitioner herein without due process of law. June 14th.
This was ad interim, limited in time.
Thereafter, it has been extended and it is subsisting till December 2023. I have that, what they call the information slip. 8th of December 2023. I'm sorry, my lord. I'll hand up copies for the time being, my lord. Let this be. I shall supply adequate copies to your lordship.
देखिए तो, देखिए फिर
হ্যাঁ দেখেই নি ডিসপুট করবো না কি করবো দেখি কপি দে ইউ ক্যানট শো এনি কপি উইদাউট গিভিং টু মি চলো স্যার দিন কপি দিন
till 2020.
Yes.
স্যার কপি দিন আমি
23,
দেখি
23, 23.
কপি দে কপি থাকলে কি করে হবে? দে
In his presence.
আরে মাইলর
Presence of the other side it is.
আরে মাইলরের কাছে কপি করতে আমি একসঙ্গে দেখবো
না না অত দেখতে হবে না তুমি নিজে দেখো এখন and this order was conveyed to the KMC with a request that please stay your hands. That letter is dated 20th of June 2019.
ডিভিশন পেই না দেবশীল দত্ত
Yes, page 47, same volume. Kindly see. Number 3, DG Building, Kolkata Municipal Corporation. Number 5, Municipal Commissioner, Deputy Chief Engineer South. Number 7. It was received by them on the same date. Some was এটা কোনটা দেখাচ্ছিস না 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 এটা দেখাচ্ছিস 11 পেজ 370 আমি আগে দেখা দেখাচ্ছি কথা উল্টো হয়ে যাচ্ছে ওটা নয় আরে চিঠির ডেটটা মিলছে না My lord, this is dated 1/11/2019. Sorry, this is not the date. I'm referring to the letter of 28th of June 2019. That is at page 370. That is at volume 2. Page 370, my lord, volume 2.
বলছি পেজ 300
My lord has got it, my lord. DG Building received it on 1st of July. Mayor received it on 1st of July. DG Building received it on also 1st of July. An executive engineer received it on 28th of June 2019 at page 373. Lordship kindly comes to page 373. In the second last paragraph, I've stated, it is noted that the promoter has got a building sanction plan without my consent and tried to encroach my tenanted property. That is all that the 3 structures, brick built, tile and tin shed, and as restored roof structure, containing an area of 5,000 square feet, more or less lying situated at premises number 16 Mondal's Temple Lane, such and such. And after expiry of the validity period of the said plan, the promoters have collected huge building materials to complete the building, ignoring the rules and law of KMC. An order of injunction as passed by the learned district judge at Alipur. Under these circumstances, you are hereby requested to take necessary action, either demolishing illegal construction or restrained to do further construction in the said property, implementing the order of injunction of learned district judge at Alipur, South 24 Parganas. Otherwise, the promoters will complete the construction illegally by depriving my tenancy right in the said property. Hope I will get your assistance. Now, in spite of receipt of this letter, the plan was renewed on 3rd of July 2019. What was the urgency? What was the haste? Good, bad, indifferent, there was an order. No, we have filed a separate writ petition because for police inaction, and in that writ petition also orders were passed on the police authorities to ensure that no further construction takes place. And in spite of that, those orders, construction took place, and we have now filed, or not now, we have already filed quantum petition that is pending. 28th of June, they have received this letter. And with, what should I say? The terrific haste,
Renewed when?
3rd of July. I have addressed it to the DG building, mayor, OC police, and again to the office of the executive engineer. That is at page 373. They have given the stamp on 28th June. Kindly see page 373 at the bottom. Copy to the executive engineer, borrow 10. Enclosure, photocopy of order of injunction. See the endorsement here, 28th of June. And 3rd of July, the plan is renewed. Before the KMC, my lord, we had relied on a circular of 2019, which replicates, my lord, the circulars of earlier of 2012, which was earlier placed by Mr. Sen. In the KMC, the defense was taken by the private respondents that it is a circular of 2019. It is not applicable because this is original plan is of 2014 and it was only renewed in 2019. So the conditions as existed in 2014 shall apply, the circular of 2019 shall not apply. The answer to that lies in section 399, I shall place that, and the circulars of 2014. These circulars, my lord, were placed before you on the last occasion by Mr. Sen. Kindly allow me to place them once again. Lordship kindly takes up the circular office order number 15 of 2012 to 2013, 8th of August 2012. দেওয়া ছিল জজ সাহেবকে। এই উপরের পাতাটা দেখুন 2012 হবে। This is the circular of 8th of August 2012. Rule 142 of Building Rules 2009 was introduced to ease out the problems of development of the tenanted buildings of the city. Owners and the tenants have to suffer a lot of problems for such age-old dilapidated buildings which surpass the expected lives of the buildings. However, this section was introduced in the year 2009. Prior to that, the issue was tackled by the department through an order issued by the municipal commissioner. During processing of those cases, department takes advice of the building committee time to time to make the process transparent, and circulars are issued to this respect. So transparency was the object. Previously, some of the members of the building committee advised to take a call on this matter and requested to make a general agenda to synthesize all the previously issued matters, that is resolution of MBC meeting dated 28/1/2010, minutes of meeting held on 6/4/2011, approved by municipal commissioner dated 11/4/2011, and office circular number 14 of 2011 to 12 dated 29/7/2011, with a resolution of MBC dated 16/6/2011 and incorporating some suggestions. The municipal building committee in its meeting dated 17/5/2012, after a threadbare discussion, advised some recommendations which are duly approved by mayor in council. Therefore, the applications under Rule 142 of Building Rules 2009 are to be dealt as follows. 1. The applicant will submit a registered declaration stating the names of the tenants, area enjoyed by the tenants, and the use group in a tabular form. He will also provide the information about the area enjoyed by himself and the existing group of the area. The statement will also include the common area of the existing building. Photocopy of such a registered declaration is to be pasted on the back of the formal sanctioned plan. Now, qua this requirement, kindly see the registered declaration that was actually submitted by them. Kindly comes to page 297, volume 2. Starts at page 296, the stamp paper. At 297, just at the beginning of volume 2. Registered declaration reference premises number 16 Mondol's Temple Lane, also known as 16 Mondol Temple Lane, PS Nualipur, Kolkata 53, ward number 81, borough 10 of the KMC. Then my lord turns over to page 301. At the bottom, my lord, point number 1, that we are the owners of land measuring more or less 27 kathas, 2 chitak, 6 square feet, together with tenanted structure measuring 13,100 square feet, standing there on being premises number 16 Mondol's Temple Lane, such and such. That we shall submit to the Kolkata Municipal Corporation plan and application for the construction of the building at premises number such and such. 3, we do hereby declare that the event of KMC granting sanction of the said plan, undertake to save the KMC harmless from the consequences of all proceeding that may be commenced or proceeded by any of the tenant and or occupier of the said premises against the KMC in respect of such sanction. 4, we will not evict any tenant. And in case it is necessary to remove any tenant, we shall undertake to provide them with incidental area in and around the premises by mutual arrangement. And other, number 5, we also undertake to make construction strictly in accordance with the sanction plan, and further agree that if any construction is made by us illegally and in deviation with the sanction plan, KMC will be entitled to demolish the same without notice to us. Then last one, 6, that if there be any dispute between ourselves and our tenant, the matter will be referred to Municipal Commissioner KMC, such and such. None of the criteria that has been laid down in point number 1 of the office memorandum of 8th of August 2012 have been met. They admit that they are tenants. They admit that they occupy 13,100 square feet. But who are the tenants? How much area they occupy? How will they rehabilitate them? So what is the purpose of this declaration? And they have said that we shall indemnify the KMC, meaning thereby, you sanction the plan, don't worry about the consequences. We shall take care of everything. Was that the object? And this is the circular of 2012. Yes. Kindly call upon the corporation to produce the records. It will make for very interesting reading. And I am told that I don't have the plan with me. That is with the KMC. But I'm told the client has taken inspection of the plan. On the back of the plan, there's a stamp that the plan is being sanctioned subject to demolition of the structures. So once the building is completed, time comes for issuance of completion certificate or occupancy certificate, building will be demolished. So where do I stand? This declaration is a sham declaration. It has the provisions of law has been totally bypassed. They have made a mockery of the circulars. And as I have said, my lord, Rule 142 squarely applies. From the registered deed, it has been shown that structures existed in 1933 when there was a deed of partition between the members of the family. The circular of 8th August 2012 was in force. The plan was sanctioned in 2014. For the time being, I am keeping aside the circular of 2019. What about this circular? That is of 2012.
This is not a circular at all. This
No,
is, this is rectangular.
This is an office order passed.
It's so serious, man. You
Sorry.
might not know.
My lord.
Since long, I'm trying to, but
I have a very insistent junior and persistent client breathing down my neck. And then Lordship comes, I handed up this bunch, kindly turns the page over. There's another circular of 10th of July 2014. Kindly takes it up. ওর সঙ্গে ছিল pin up করা।
Oh, yes. Now,
লুজ কেন হবে? তা পুরো একটা শিটে আমি পরপর সাজিয়ে দিয়েছি ডেট ওয়াইজ। খুললো কি ওগুলো ওখানে?
একদম শেষ কর না, হয়ে গেল, অনেক হয়ে গেল।
Lordship has got this, my lord, 10th of July 2014. Now, it is circulated for all concerned that at the time of acceptance of the application under section 393 of the KMC Act 1980, read with rule 142 of the KMC Building Rules 2009, one affidavit from the applicant has to be obtained along with other necessary documents. The affidavit should be notarized, enclosing the consent of the tenants to demolish the existing building in compliance with Rule 142(3) of the Building Rule 2009. The said affidavit has to be submitted before sanction for those applications which has already been submitted and under process without such affidavit. So, if as on 10th of July 2014, certain sanctions were pending, in which case this registered declaration or affidavits were not given, they were to comply with that, and only then the plan would be sanctioned. Now, this provision remained in force in 2019 when they applied for renewal. So, the question that I ask myself, if this was applicable in 2014, in case of pending sanctions, and they were kept in hold, that unless you put in this affidavit, how you rehabilitate your tenants, why should not this criteria be met when the plan is submitted for renewal? If this applies in 2014, it applies as well in 2019. The circular of 2019, which I have relied on, speaks of the same thing. They have said, no, it is of 19, plan is of 2014. So I'm keeping it at bay. I'm relying on the circulars prior to 2014. And that was of 2012 and this additional one of 2014. So the criteria of registered declaration remained not met, not complied with in 2019, as also this criteria of furnishing affidavit. That also remained not complied with in 2019 when the plan was again submitted for renewal. And I draw your ship's attention to the language of the registered declaration that we shall keep you indemnified. Don't worry. And now section 399 there. Yes. The circular which we relied on, that was of 19th of February 2019. May I place that? Which they said will not apply because plan was of 2014. That is at page 200, volume 1. The origin. This is the typed copy, my lord, at page 200. This is the photocopy of the original circular. It's the same thing, but because
অন্য কাগজ দিচ্ছে আমাদের দিচ্ছে না
page 200. Lordship complains is the same thing. It's a typed copy at page 200. Date is of 22/2019. Subject protection of tenants' right for the sanction of building plan under Rule 142 of the KMC Building Rule 2009. During processing of the application under Section 393 of the KMC Act 1980, read with Rule 142 of the KMC Building Rules 2009, applicant has to ensure and undertake that tenant rights are protected in terms of the West Bengal Premises Tenancy Act at the time of sanction of building plan and execution of the same. 1. A registered undertaking or affidavit has to be submitted by the applicant with the following statements or documents. The tenant's right will be protected in terms of the West Bengal Premises Tenancy Act at the time of sanction of building plan and execution of the same. 2. Area statement existing and proposed along with use group existing as proposal against each tenant and owner in a labor form. The area statement will include the respective common area enjoyed by tenants and owners except exempted area in terms of Rule 69 of KMC Building Rules for existing and proposed building. Then number 3, written consent of each tenant. The tenant has no objection on the proposed development or demolition of the existing building and the constructed area proposed in the submitted plan in compliance with Rule 142(3) of the Kolkata Building Rules 2009 for the identity of each tenant. So this basically is a compilation of the two circulars of 2012 and that of 10th of July 2014, 8th August 2012 and 10th of July 2014. Same thing. Even if it is held that this will not apply, those two will squarely apply.
What is the effect of such a circular? It's binding on the corporation.
And if the violation is made, then the sanction becomes
There's
illegal.
case law on this.
And it is a judgment, I believe, that was delivered by your lordship on the case of renewal of sanction plan. Where I do not know, my lord, whether they had given any fresh declaration at the time of renewal. The only declaration that we have come to know is that of the one made prior to the sanction of the plan in 2014. Whether in 2019 they had given another declaration, I do not know. But from their pleadings, it appears that no such fresh declaration was given, because they have always consistently maintained that the circular of 2019 shall not apply. It was a plan of 2014. My lord, may I cite a division bench judgment of this honorable court presided over by my lord Justice Banerjee, which dealt with section 399 of the KMC Act. I'll be citing, my lord, paragraphs 14, 25 and 26.
Yes, kindly don't peruse it. Don't peruse it. No copy has been given. না আগে দাও তারপর দুজনকে দিতে হবে, কর্পোরেশন হাঁ করে বসে আছে। হ্যাঁ, দাও, আপনি দেখাতে পারো না।
Paragraph 18, my lord, at page 14, section 399 has been set out. That is the period of completion of building or work. The municipal commissioner shall, when sanctioning the erection of a building or the execution of a work, specify a reasonable period within which the building or the work is to be completed. And if the building or the work is not completed within the period so specified, it shall not be continued thereafter without fresh sanction obtained in the manner herein before provided, unless the municipal commissioner on an application made in this behalf allows an extension of such period. And then in paragraph 23 at page 18, my lord, it's a rather longish paragraph. I'll read from the beginning. At page, kindly come to page 17, my lord. Paragraph 23 at page 17. Section 399 of the KMC Act requires the municipal commissioner at the time of sanctioning a building plan to specify a reasonable period within which the building is to be completed. It further says that if the building is not completed within the specified time period, construction shall not be continued without application or fresh sanction unless the municipal commissioner on an application made by the builder allows an extension of such period. Rule 15.3 of the KMC Building Rules 2009 specify that the initial sanction will be valid for a minimum period of 5 years, which has been taken to be the reasonable time contemplated in section 399 of the Act. However, the municipal commissioner may renew the permit for a further period which will not exceed 5 years. In other words, the original and the extended period taken together must not exceed 10 years. These stipulations are made in larger public interest. A building permit cannot be allowed to remain valid for an indefinite period of time. With passage of time, various factors in the society undergo change, which may require change in the building rules. The legislature, in its wisdom, has thought it fit to permit the municipal commissioner to extend the validity of the sanction plan up to a period of 10 years, provided the builder makes an application prior to expiry of the original validity period. However, once the original validity period expires, the builder has to obtain a fresh sanction, generally in accordance with the building rules prevailing on the date of application for fresh sanction. So, if he has sought for renewal after the expiry of the original date, it amounts to a fresh sanction. In that event, 2019 will apply. Even if it does not, even if he had applied within the validity period, then also the circular of 2012, 8th August 2012 and 10th July 2014, those will apply. 2019 circular is basically a compact circular incorporating the provisions of both 2012 circular and 2014 circular in one circular. So it does not really make any difference. And lastly, my lord, I shall cite the famous case of Supertech Limited versus Emerald Court Owner Resident Welfare Association. This was decided by the Supreme Court, and thereafter 2 high-rises were demolished. And Lordship recalls it created quite an stir at that time. Videos were viral all over the social media and even in TV channels constantly. The demolition was beamed, how it was done without inflicting any damage on the surrounding portions. The head note is there, and my lord, paragraphs 159, 160 and 161. The citation is 2021 10 Supreme Court cases, page 1. May I, the summation is given in the head note. May I place the main paragraphs I'm relying on from 159 and 160. That is at page, my lord, 86. এই unreported judgment-এর copy দাও, আর ওই slip-টার copy দাও, information slip-টা পাঠিয়ে দাও না xerox করতে, দিয়ে দেবে এখানে। Lordship has got it, my lord, page 86, paragraph 159. The rampant increase in unauthorized constructions across urban areas, particularly in metropolitan cities, the soaring values of land place a premium on dubious dealings has been noticed in several decisions of this court. The state of affairs has often come to pass in no smaller measure because of the collusion between developers and the planning authorities. Supreme Court has taken, my lord, judicial notice of this nexus. From commencement to completion, the process of construction by developers is regulated within the framework of law. The regulatory framework encompasses all stages of construction, including allocation of land, sanctioning of the plan for construction, regulating of the structural integrity of the structures under construction, obtaining clearances from different departments, fire, garden, sewage, etc., and the issuance of occupation and completion certificates. While the availability of housing stock, especially in metropolitan cities, is necessary to accommodate the constant influx of people, it has to be balanced with two crucial considerations: the protection of the environment and the well-being and safety of those who occupy these constructions. The regulation of the entire process is intended to ensure that constructions will have a severe negative environmental impact are not sanctioned. Hence, when these regulations are brazenly violated by the developers, more often than not with the connivance of regulatory authorities, it strikes at the very core of urban planning, thereby directing result in an increased harm to the environment and a dilution of safety standards. Hence, illegal construction has to be dealt with strictly to ensure compliance with the rule of law. So in this case, my lord, plan sanctioned in violation of in brazen violation of the rules has to be taken as illegal construction. Lordship will kindly ask for the records, because there are many gray areas which will come out from the records. Lordship will be able to see the plan which has been sanctioned and the stamp on the back of the plan, which I was mentioning, that this plan is sanctioned subject to the demolition of the 3 structures. So when the final completion certificate, now they are saying, no, their interest is protected. I have protected the interest of the tenants on the West Bengal Premises Tenancy Act. Those 3 structures are there. Where are they? In the driveway. And the plan sanctioned clearly says that this is sanctioned subject to the demolition of those structures. So when the final time comes of issuing completion certificate or occupancy certificate, then where do I go? And this registered declaration, it doesn't comply with any of the provisions laid down in those 2 circulars. It's a sham. And what is the purpose of taking the declaration? It must serve a purpose of protecting the interest of the tenants. Just for issuance of the sanctioned plan, I put in a declaration which doesn't comply with any requirements. I get the plan sanctioned. It makes a mockery of law. What is the purpose? They could have done away with the requirement of putting the declaration and the affidavit. When it has been put in, it must serve its purpose. That's all, my lord.
Issue.
কি বলি একটা হার্স ওয়াজ ধরবি মকারি ছাড়া
Reopening week, Mr. Basu, reopening week?
reopening day there may be the following day.
There will be.
I don't know. God only knows. The following day.
Yes, reopening week, I said.
Yes, it's on the following day.
Mr. Dotto.
I have one prayer, my lord. Kindly pass a direction for producing the records.
Not now.
KMC.
We will if necessary. Let's hear Mr. Basu.
Why is he so afraid of the records being produced?
No, we don't want to. We are not on that. We'll trouble KMC if it's necessary. Let us hear Mr. Basu. Mr. Dotto, learned advocate.
KMC, it's Mr. Basu who is objecting to the production of plans.
Learned advocate for the appellant. Concludes his opening submission. Paragraph as requested by Mr. Basu, learned senior advocate appearing for the private respondents, let this matter stand over till after the puja vacation
It's a date, on that date I'll come.
and be listed again on November 17, Friday. 16th we reopen.
Reopening, 17th is Friday. That's why I remember, because 18th another thing is going to happen.
16th of November is Thursday.
That's why I remind 17th is a Friday.
Let it be there on the 17th, we'll see.
Yes, yes. থাক না 17th. Ready হয়ে যাও। চাপ থাকবে না?
My lord, another small prayer. May it be marked as part heard. Lordship has heard it at considerable length.
এটা নে। নেবো না, নেবো না। তো জিনিস।
ছোটখাটো জিনিস কেন?
Number 40.
In this item, Mr. Alok Kumar Ghosh is appearing on behalf of the appellant, and he is engaged in courtroom number 15. My lord, I am praying for not today.
My lord, Mrs. Arafin is for the petitioner. My lord, he is coming. Kindly pass over the matter, my lord.
This is second call, na? Second call, madam. Where is he?
He is coming, my lord.
Who is for the respondent? Do you know?
No, my lord, I don't have any idea.
Not today.
State is not there. I think state is required to be present, my lord.
State's presence is necessary, na?
Yes, my lord. They have filed affidavit, my lord, district magistrate stating that the entire directions of your lordship has already been complied with. That report has been filed in the form of affidavit. Now my learned friend is taking exception to that report.
You are filing exception. File.
But no copy has been served upon.
He'll give copy.
My lord, one thing, my lord, in this case, my lord, I have seen, my lord, your lordship, can you recollect in this matter, Mr. Hon'ble was appearing. Now, for some reason, he has taken relief from this brief. My lord, your lordship, in an earlier occasion, my lord, added my learned friend's client as intervener in a contempt proceedings.
No.
Probably so. My lord, if that be so, my lord, he himself has come up to join as a contemptor, then I have nothing to say. Because in the contempt proceedings, intervener has no role. And my lord, there is no such, my lord.
I am not the intervener, your lordship knows.
My lord, 3 persons.
Exception of the petitioner. Lekho. Exception of the petitioner to the report in the form of affidavit filed by the district magistrate, Jhargram, be kept with the records. Stop. Let copies of such exception be made available to learned advocates for the other parties. Paragraph. Mr. Ray, after vacation, let this matter be listed again immediately after the puja vacation on November 17, 2023. We have to catch up on a lot of pending judgments. Therefore, we don't want to take up any more. And this will be like a hearing matter.
Very recently, the Supreme Court came up with this, they dealt with this, so far as the intervener in a contempt proceedings.
But the intervener is not here.
You are not the intervener.
No, my lord.
He is not the intervener.
My lord,
probably.
my lord, may I just clarify, my lord?
He is one of the respondents.
Alleged contemptor, my lord.
Respondent,
My lord, in fact, my lord, administrator was made a party as alleged contender. Since the administrator is not there, chairman is there, your lordship was kind enough to add the chairman. And that order has already been complied with in its entirety. my lord.
That I will submit before the lordship.
41 plus. Kita way to let him.
Item number 41.
This is application for contempt. The last occasion, your lordship direct me to serve copy. May not have serve copy. I file affidavit of service also. Your lordship will find page 1414. This is the order which has been passed by the honorable division bench. Thereafter, another order passed within 2 days has given to correct the record of right. Nothing else. Update the record of right. Only register 8 he will correct. He will not be corrected from kindly see from 2014 to 2023. And also thereafter order was passed. 2 days has given. Within 2 days you do it. This is an honorable Chief Justice. In spite of that, that was not done.
We need to,
Let the rule be issued below. Then it will be completed. If rule issued below, they will complete.
what is this can one?
That was your lordship allow it for add as a party new incumbent.
Can one is disposed of?
Yes. But I have already.
Have you amended the cause title?
Yes, sir.
Yes. Issue. On the last occasion, i.e. on September 4, 2023, Mr. Dhor, learned advocate who was representing the original respondent, was requested to take instructions as to whether or not he will also represent the added respondent, who is the present BLL Block Land and Land Reforms.
Land Reforms Officer Bhatar.
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 BHATER, Bhatar, District Birbhum.
Purbo Bardhaman. District Purbo Bardhaman.
কি বলছে? ডিস্ট্রিক্ট পূর্ব বর্ধমান?
Yes.
আচ্ছা, হ্যাঁ পূর্ব বর্ধমান, correct. Paragraph. Today nobody appears for the added respondent. Added respondent has been served.
Yes, sir. He has appeared, therefore he has appeared.
No, he had appeared for the original respondent.
No, that was served. Affidavit of service.
Where is affidavit of service?
File আছে দেখুন file.
দেখো দাও।
File আছে আমি দিয়েছি দেখুন। Twice I have served, not one. The copy also with me. A copy also with me. He has received it.
Mahadev Mondol.
His name Madhav Mondal.
You have written Mahadev Mondol in the petition. You are appearing for the added respondent.
Instruction fine. আপনি কি সার্ভিসটা করেছেন? হ্যাঁ হ্যাঁ। মানে ঠিক অ্যাড্রেসে সার্ভিস করে ওরা কিন্তু ভাতার তো ঠিকই অ্যাড্রেস একটাই তো MADHAB মাধব মন্ডল
মাধব or মহাদেব?
মাধব মন্ডল
But petition.
Mr. Arifin, you have added Mahadev Mondol as contemnor. Mahadev.
But I have correct my copy Madhav Mondal.
In our copy, it's Mahadev Mondol. We have not done it. You have done it. Your
Yes,
junior has done it.
I did it. Madhav Mondal.
And in your affidavit of service, you have written Mahadev Mondol.
And also another melody.
You are creating this confusion yourself. Speed post you have sent to Madhav Mondol. Now, how do we know whether it's Mahadev or Madhav?
Madhav Mondal. No, Madhav Mondal his name.
I'll have to take the instruction. Give me.
Madhav Mondol has been served.
Madhav Mondal his name. আমি শিওর আমি 5 বার গেছি ওর কাছে মাধবের কিছুতেই করবে না
Mr.
Just go out and
Go out and find out. We are about to issue rule. Find out.
মাধব মন্ডল
আর কিছু হবে না।
দ্বিতীয় চিঠিটা সেদিন মাধবকে পাঠালাম মাধব মন্ডল মাধব মন্ডল Now that will be Madhav Mondal. I will correction for you. না একটা মহাদেব হয়েছে একটা মাধবকে পাঠিয়েছিল এটা ভুল মাধব তাদেরকে অর্ডার করা যায় মায়া কাঠের মাধব মন্ডল
Mr. Dhar, Madhav Mondol has been served. We have seen. But since you are there, kindly take this responsibility. We'll post this matter again on Monday. You take instruction.
my instruction
If you appear for him, we'll direct affidavits. If you don't have instruction, we'll issue rule.
No, I have the instruction.
Then you are appearing for him.
You appear.
Previously, Indian BLLRO has given me instruction to appear. Thereafter, the BLLRO has changed. So the present incumbent has not got in touch with me.
So now kindly, if he has not got in touch, you please get in touch, ask him. Otherwise, he'll have to come, leaving his work, answer the rule. Therefore, Esho, Lekho.
Now, my lord, I can't find, my lord, what is the grievance of?
The records of rights have,
Registration 8 will be corrected as per update record. But this order was passed by the Honorable Chief
My lord,
Justice.
kindly come to the original order.
Yes.
yes, what do you mean original order? There's only one order of which violation is alleged.
Yes.
Come to page 15 of the contempt petition.
Update the record. Second page.
Respondent number 3, third line from the top.
Oh, yes. এটা অরিজিনাল অর্ডার তারপরে আবার চিফ জাস্টিস অর্ডার দিয়েছিল 2 দিন সময় দিলাম তুমি আপডেট করে দাও
সেটা করে দিয়েছি
না, করে না।
this register 8 in respect of the suit, which that suit schedule property, if I could show before my lord that
Mr.
all
Dhar,
register 8 in respect of the schedule property mentioned in the suit code.
I shall leave
feel
my
something to show that.
advocacy. I shall leave my advocacy. This is my case, personal case. I leave my advocacy if he shows it. That he has correct the register 8 total.
Let him show. The problem is, problem is, Mr. Arifin, he can't tell us if he's appearing for the added respondent. If he tells us, we'll immediately direct to exchange of affidavits.
I have given all the numbers which had not been done. All the numbers.
Let us issue a rule then, Mr. Dhar, because if you are not sure that if you are representing the added respondent, he has received notice, we'll issue a rule. Issue. Kichuri বলেছিলাম না on the last.
Kindly see this.
No, nothing. You are not even representing him. We don't want to see.
খানিকটা করেছে খানিকটা করে না এই জন্যই তো আমি দিয়েছি ওখানে ওগুলো যে এগুলো করে না ও বলছে আনুক খাতা রেজিস্টার 8টা নিয়ে আসুক let them come with the register.
I was given this report on 7th September. Kindly have a.
Why you are not even appearing for respondent number 7, the added respondent? Paragraph today, Mr. Dhar says that today, Mr. Dhar says that he has not been able to get in touch with his client. Stop.
Instruction on 7th September.
We are not concerned. We want a statement from you. Either you are appearing for the added respondent or you are not.
I am happy.
Fine, file an affidavit. Today, Mr. Dhar appears and says that he is representing the added respondent, comma, Mr. Madhav Mondol.
আমি দেখেছি
Khan, Naki Mondol. Mr. Madhav Mondol.
আমি বলছি
Stop.
আমি দেখেছি সব
ঠিক আছে?
অর্ধেকটা করেছে
Paragraph, let the added respondent file an affidavit responding to the averments in the contempt petition, comma, within 1 week after the puja vacation, date diye dao, stop, reply thereto, comma, if any be filed within a week thereafter, date diye dao. Paragraph lists this contempt application once again on December 4.
yes no. Let him to file everything তোমার যেতে বলছি না তো আমার যেটাই ডিগ্রি আছে সেটুকু আপডেট করো হ্যাঁ আমার আর কিছু করতে হবে না সম্পত্তিগুলো বেচতে পারছি না আমি সব বেচতে রেখে দিয়েছি
Item number 43.
Item number 43, I am appearing on behalf of the alleged contender, my lord, praying for not this week, my lord.
Not this week.
My lord, I am appearing for the petitioner, my lord. But this matter was running in the list for quite a long time. The only difficulty, my lord, the contempt is the changing the nature and character of the suit property in spite of an order of status quo. The primary allegation is that they are conducting Durga Puja in the said land, my lord. The said suit property in spite of an order of status quo by this division bench, my lord. My lord, now if this matter is adjourned today, my lord, they are already taking steps for conducting Durga Puja this year also. So, my lord,
You don't want puja to be held.
no, my lord, that I won't oppose because when I am holding the brief of
Temporary structure, if they put up a pandal and worship God, the goddess Durga,
no, my lord, that I won't oppose, but I am holding the
come back immediately come back on the reopening day. There will be not too many learned advocates. We'll hear out your matter.
my lord. My lord.
Accommodation is prayed for on behalf of the alleged contemnor. Stop. Paragraph. List this matter once again immediately upon reopening after the puja vacation on November 16,
My
2023.
obligement. Hadid. 45.
My lord, I'm appearing on the behalf of the petitioner. My lord, praying for not this week. Because my learned senior is not present at the court due to some
Let
personal.
it be not this month. After vacation, madam. Accommodation is prayed for on behalf of the review applicant. Stop. The puja vacation is knocking on the doors. Paragraph lists the matter immediately after reopening on November 17.
Highly obliging.
47.
My lord, I am for the appellant, my lord. Mr. Shomo Majumdar is appearing in this matter. He is busy in courtroom number 550. My lord, kindly keep it in after vacation, my lord.
Yes. Accommodation is sought for on behalf of the appellant. Stop. List the matter immediately after the reopening on reopening day, November 16.
Okay.
Arey Baba,
48.
Lord, I am appearing for the appellants in this matter, my lord. Lordship had directed filing of paper books. Paper books have been filed, my lord. Lordship had also directed service of notice of appeal. I believe that has also been done, and we have also served the paper books upon the respondents, my lord. Appeal is ready for
nobody is here. No further hearing matter.
as my lord pleases.
The respondents are not represented. Stop. Learned advocate for the appellant, in his usual fairness, says that he would not like to proceed ex parte. Paragraph lists the matter after the reopening on November 16.
My lord,
16th November.
my lord, kindly not, sir, kindly not read it. It does not want to proceed ex parte, my lord. Kindly
তাহলে
please
বলো না।
that point.
এটা বলো এরকম ভাবে বলো। Nobody কি বলেছি? Stop. We are very close to the puja vacation and we would not like to proceed ex parte. Stop. Tarpore list the matter on.
Deeply obliged.
Yes, Howrah Zilla Parishad is your client.
Yes,
That is the
fine, my
difficulty.
lord. Otherwise. Oh.
49.
I'm happy for the state Boshumati matter.
Boshumati, not this side.
Chatterjee, Ranojit Chatterjee.
Not this side.
Requested by
After vacation, Mr. Is this matter 1 week after the puja vacation on date ta diye dao 23rd November. November 23, 2023. তার আগে একটা লাইন দিয়ে দাও, all the parties are not represented. তারপরে এটা বলে দাও। Your appearance will go, give it.
No purpose will be, sir.
You're not appearing.
No, Mr. Ranojit Chatterjee is there. His clerk requested me to take time.
Very well. You appeared, now you may disappear because it has been adjourned.
Once again, one request, my lord, on behalf of Kolkata Municipal Corporation, this time, appeal.
What is the request?
My lord, after vacation.
After vacation.
Lordship, I am for the respondent.
On the, এগুলো সব রেকর্ড করো বাবা। Accommodation is paid for on behalf of the appellant. Paragraph, list this matter 1 week after the vacation. Date ta diye dao. Who is appearing for KMC?
Vishwajit Mukherjee. I guess.
I am for respondent petitioner.
51.
I am for the corporation. I am from the corporation. Appellant is
The appellant is not represented. Stop. Let this matter be listed on November 20.
great video, Lordship.
52.
52, my lord, appearing for the appellant, my lord. And my lord, I'm praying that this appeal to be heard this side of the vacation, my lord. It's a very short matter, my lord. Nothing left in this appeal, my lord.
Nothing left.
Nothing left. my
In
lord.
view of the Supreme Court decision.
Yes, yes.
Then why are you pressing this appeal?
My lord, that is my instruction, my lord, to press this appeal.
Unless there is a scheme in the municipality, no
No,
compassionate appointment can
that
be given.
point, my lord, that point to be argued, my lord, hardly it will take 15 to 20 minutes, my lord. I shall,
Who is on your other side?
my lord, the state and Baranagar municipality is my other side.
Who are the learned advocates?
Mr. Pinakidhol is appearing
You
for the
speak
state.
with them. If you come back tomorrow or on Monday,
Monday I shall take up.
the respondents are not represented. Stop. Learned advocate for the appellant says this is a very short matter
Yes.
and can be disposed of before the vacation. Paragraph. List this matter once again on October 16, 2023. Stop. Let notice be served by learned advocate for the appellant on learned advocates for the respondents.
সোমবারে শুনানি।
53.
Nobody appears for the parties. Stop. List this matter once again on November 20.
And I'm the appellant, my lord. And it's not a long matter, my lord. Since it's 3:30, if it can be fixed on any date on this side of the vacation. Otherwise, if my lord wants, I can place the matter today itself.
Your other side is here.
This side is, other side is, my lord, not here. May I file the paper books in court,
File.
my lord?
Paper books filed on behalf of the appellant be kept with the records. Stop. The respondents are not represented. Paragraph. List the matter once again on October 16, 2023. Stop. Let learned advocate for the appellant put survey notice on learned advocate for the respondents, intimating that this matter will be listed again on October 16.
Next two matters, my matter, my lord. I am appellant, Raiganj municipality. State is also here, my lord.
You are appellant.
Not here.
But I am
Next.
appellant.
Shukumal Sarkar.
Yes, Sukumal. Sukumal Sarkar, Narayan Chakraborty possibly. Two matters.
Acha.
বলুন কি বলছেন?
My lord, can it be kept after vacation, my lord?
So in that case, my lord, 22nd November, if subject to lordship availability.
দুটোতেই same order করবে. Learned advocate for the municipality. Raiganj municipality prays that this matter be taken up after the Puja vacation. Stop. Learned advocate for the appellants says that this matter may then be listed on November 22. Stop, let that be done.
May I be permitted to mention item number 32? I could not appear on time. It has been dismissed for default. May that
32.
32. I was appearing put number.
এই 32 টা তো চলে গেছে চেম্বারে, ওটাকে বার করে নাও, ডিসমিস করো না, নট টুডে করে রেখে দাও।
Grateful, deeply obliged. I apologize for my conduct. I was stuck in another.
শেষের দুটো, হ্যাঁ, let that be done, হ্যাঁ, শেষের দুটো।